My lord's kind leave to mention a matter, my lord, for first appeal for inclusion in the list, my lord.
If it's not a hearing matter, then mention.
My lord's
Hearing of appeal, we are not taking up right now. One second.
my lord, can fix a date, my lord, if it may appear as to be mentioned, and then my lord, this can be subject to my lord's, my lord.
What is that? Yes.
My lord, I was humbly submitting, my lord, let it appear as to be mentioned. A date can be fixed thereafter, my lord.
Hearing matter, no. এখানে সই করতে হবে।
My lord, matter related.
Sorry, yes.
My lord, matter related contempt matter from Jalpaiguri Circuit Bench. So it was early
Single
mentioned-
bench. My single bench.
No, sir, double bench, Justice Prosenjit Bishwas. The file on at Calcutta.
Mention it will have to constitute a bench. You can approach the Chief Justice for constitution of a bench. We'll have a talk with Justice Bishwas very well. এটা নিয়ে নিন ফাইলটা, এই স্লিপটা নিয়ে একটুখানি মনে করিয়ে দেবেন, আমার পিএ কে একটু জানিয়ে দেবেন যে জাস্টিস বিশ্বাসের সঙ্গে একটা বেঞ্চ ঠিক করতে হবে, সেটা হবে। We'll notify. Yes.
My lord, my matter is.
Let us continue. Yes.
My lord, may I be permitted to mention one fast appeal for hearing matter?
Hearing, please don't mention. We have taken several mentionings yesterday. No further. Yes.
Kind leave to mention one matter, my lord. This is a Group 3 appeal since my lord is in charge of the urgent determination.
Justice Mantha,
My lord. That is the
but
reason I'm
can we take it up by today? Because Justice Mantha will be sitting tomorrow. So if before the file comes, I mean, I don't think it will be
my lord,
feasible to take it up today. What is the urgency?
My lord, the urgency being, my lord, before the honorable, my lord, trial bench, my lord, the matter is fixed tomorrow. My lord, and my lord, there is a direction for making payment to the, my lord, Provident Fund authority.
Could the writer later that the regular bench is not sitting? Because if we direct the file to come today also, we don't know when it will be taken up by us.
My lord, the difficulty is, my lord, yesterday, my lord, we have given a sleep, my lord, before my lord, because my lord, the bench was not sitting, my lord, yesterday also.
Oh,
Lord, there is
then hand
my
over the slip. Hand over the slip. If the file comes, we'll put it at 2.
my
এটা একটা supplementary list issue করিয়ে দিয়ে এটা 2 PM রাখবেন. Give a notice to the other side if you
my lord, I shall deeply obliged. My
Yes.
Lord, I am praying for inclusion my applications.
Application? Yes, yes. Applications and other mentionings, please hand over. Unless it's a appeal hearing, we are not taking it.
My lord, I may be permitted to mention, bring to your notice one matter, my lord. Order was passed on 6th of January.
Correction of order.
No, my lord, it is something different. Like here, the it was a restitution conjugal rights decree in favor of my client, who is the respondent herein, my lord. In this matter, somebody appeared on her behalf without she giving her any wakalatnama to these two advocates whose names are being here. Because when she contacted me, I quickly checked the latest order.
Ma'am,
My
please file a formal application,
My lord.
1 or 2 page application, and mention it before us. We'll list it,
My
give
lord,
a
because
copy to the other side,
my
and
lord,
we'll take it.
order has been passed already. The stay order has been confirmed, my lord, by this. By
That
your
we'll
court.
consider.
My lord.
Just give a notice, file a 1 or 2 page application affirmed by your client,
My lord.
and give a notice to your other side, not the
My
people who appear. Give a notice to the other side and mention it. We'll take up the application and pass necessary.
Deeply obliged, my lord. Deeply.
May I have your lordship's kind leave to mention order 41 rule 11?
Yes.
Milord, inclusion and Milord, I'm praying Milord for listing today or tomorrow itself. Why? Milord, this is a suit filed by a tenant from disposition without following the due process of law.
If the file comes, it will appear tomorrow. Sir.
Well, now Milord, what they cannot do, they could not evict me. They have started.
We cannot
demolition.
list it before tomorrow. Hand over the slip. File আজকে requisition করে নিন. Yes.
Because item number 50 and 73 is concerned, my lord.
Yes.
Lord, if the business of the court doesn't permit me, Lord, to take up the matter, my lord, till the recess, my lord. After recess, my lord, I will not be available, my lord. I will be out of station till tomorrow. So in that event,
We don't know whether we can take it up even after recess.
If my lord, business of the court doesn't permit, my lord, kindly accommodate me for.
Yes, yes, no, did not mention for that.
Great.
My lord, FAT 165 ex-party hearing.
হিয়ারিং ম্যাটার আমরা এখন নিচ্ছি না।
ডিসেম্বরে আসছিলাম মেনশন করছি
না, আমরা নিচ্ছি না, আমরা গতকাল নিয়েছি আর নিচ্ছি না এখন। সরি, কল অন দ্য লিস্ট।
Lord, AD1 I beg to appear, my lord, for the IOCL.
FMET 237 of 2017 is allowed on contest without any order as to costs, thereby setting aside the impugned judgment and order dated June 21st, 2016, passed by the Railway Claims Tribunal in claim application number such and such. The respondent, Southeastern Railway, is directed to refund the additional 20% surcharge on freight to the appellant to the tune of rupees 1 crore 14 lakh 5,071 along with interest at the rate of 6% per annum from March 2013 till the date of payment within February 15, 2025. In default of payment within the said date, additional interest at the rate of 6% per annum, payable on and from February 16, 2025, calculated on the total sum, including the principal plus interest till February 15, 2025, till the date of payment shall be paid by the respondent to the appellant.
Grateful, my lord. Deeply obliged.
My lord, in this matter, I am for the appellant, my lord. What happened in this case, my lord?
Yes.
This appeal is, my lord, under section 20 of the Hindu Sanction Act for exercising preferential right. It is pending. The appeal has been admitted, and the appellant, Asa Das, my lord, she expired. Thereafter, my lord, an application was filed, that is can number 11307/2024. For my lord, note that the death of Asalota Das, appellant number 1A, and also to make the note that the legal heirs of the deceased appellant 1A are already on record as appellant. This, my lord, her son and daughter.
What do you want now?
This
This application, you want this application to be heard?
No, my lord. I went, my lord, to the department, and office said that you mentioned the matter, and this after admission of the appeal, my lord, this application may be treated as ignored.
You said the appeal has been admitted?
Yes, appeal has been admitted.
If the appeal has been admitted, division bench does not have any further determination. Whatever application is filed, whatever orders are to be passed by the single judge, taking up second appeal matter. You have an application now that is to be heard.
Not heard, my lord.
What order are you wanting?
I am this application, my lord, may be ignored, become infructuous.
Mention it before the concerned single judge who is taking up applications in connection with second appeal, and get that order passed. We don't have determination. You are sure that the appeal has been admitted?
Yes.
Very good. Learned counsel for the appellant submits that the present second
Admitted on 6th March 2019.
Achha. Yes, right. Learned counsel for the appellant submits that the second appeal has been admitted by an order dated March 6, 2019. Full stop, next para. Learned counsel now seeks to not press an application in connection with the appeal. Full stop, however, comma, since the concerned learned single judge and not the division bench has determination to take up applications in connection with second appeal after the same is admitted, comma, let the matter go out of our list with liberty to the learned advocates for the parties to mention for enlistment before the appropriate learned single judge having determination. Thank you.
Item number 3, I prefer not today, my lord. I am for the appellant, my lord.
You have it is appearing in the list for under to be mentioned for praying for not today.
Yes,
No. Why is it appearing as to be mentioned?
due to illness, he has not come today, my lord.
Why is it appearing as to be mentioned?
I do not know, my lord.
Not today. On the prayer of the appellant, the matter is adjourned for the day.
Yes, my lord, only one.
Mentioned it. You should have taken instruction why it is appearing as to be mentioned. When somebody requests you for this also appearance is required to be recorded.
File or paper book file, my lord.
Paper book filed. Anyway, next.
Lordship, in this matter, I am appearing for appellant petition, Section 5 application.
Section 5. You have not yet served?
Yes, madam.
What about the service?
Service. Both the envelopes returned.
Good service has been effected?
No, madam. They are left. They are living in the same house, but return to envelope.
You have sent at the address which was
Yes,
given by them in the plaint.
Properly addressed.
No. You are for the defendant. You are the defendants in the suit or the plaintiff?
I am for the appellant petitioner.
In the suit, what were you? This arises from a suit. You were a plaintiff or a defendant in that suit?
The suit, I was plaintiff.
Plaintiff.
Suit was filed before the city civil court for partition and injunction before the defendant inducted third parties in the undivided property.
Right.
The suit was had ex parte. I annexed all the documents, even the
Your suit was dismissed ex parte.
ex parte for failed to consider, my lord.
But then you have to ascertain the correct address of the
Only,
defendant.
correct address, my lord.
You do ascertain that.
This application I am praying for only the condonation of delay during the appellant petitioner was senior citizen.
Condonation of delay in filing the appeal.
No, my lord. Appeal was filed in time. Substitution application, the defendant.
But for that you have to serve a copy on the opposite party. Only sole respondent has died.
Sole dependent respondent had died. He has only two sons, Soumitra Sil and Pavitra Sil.
Why 3 applications? Can 2, 3?
One for application section 5, one for substitution, and another for injunction petition.
Section 5, what is the number of the Section 5 application?
4, my lord, 4. Can number
Can 4. Let us find out Can 4 first. Yes, Can 4. What is the delay?
Delay 1,000. That's it, I can't read. 1,621 days because the appellant petitioner was seriously in bedridden condition, senior citizen. His wife also the same. The medical certificate are annexed herewith. Even the advocate for the appellant petitioner was undergone hernioplasty.
1,000 something means over 3 years.
Yes, no, the corona period was intervened and.
Corona period in when did the respondent die?
Died, my lord. Yes, died.
2018, 2 years before the corona.
Died on 22nd December 2018.
So that was 2 years before corona.
Yes,
1.5 years before corona. What is your explanation for that?
The appellant petitioner was seriously ill, my lord. He cannot move outside his house. His wife also. The advocate for the appellant petitioner was under.
You please serve a copy on the you tried to serve on these respondents, the substituted respondents. This service was thought to be effective on the
substituted respondents.
But then you have to ascertain the correct address. Without hearing them, we cannot condone such a long.
Living in the same house.
Living in the same house. You are saying that, but the suit was decreed dismissed ex parte. Therefore, they have consistently not been appearing.
Kindly in the suit and in the injunction petition, the registered will and probate and all the documents annexed. But the learned judge, when the examination in
No, we are not bothered about that. The suit also was dismissed ex parte. They had not appeared in the suit also. If they did not appear in the suit, presumption is that they might not have been served then.
Yes, I also served them in the suit.
There it was served. The summons was served. In this address only.
Yes, my right. Here I have served. And when the suit was filed, the application and the copy was served to them.
Let us see the explanation in the Section 5 application. Please come to the Can 4. What is the explanation? Please place that.
Judgment, annex here.
No, we want to see a condonation first. The ground for delay. It's a huge delay, so we want to be satisfied on that first. If they live in the same house, then you are aware of the date. You are aware of the death on the date of the death.
Advocate for the petitioners was living then in a remote village. He informed over phone. Thereafter, my lord, the advocate for the appellant petitioner was ill after operation. He declared that he will not be able to come to court, engage another advocate. Then he requested the advocate on record to.
What is the age of your? What is the age of your client? What is the age of your client?
About 75 now. An advocate for the appellant petitioner was in her 70. All of them senior citizen.
The same. What happened to that advocate? The previous advocate?
It was undergone. Medical certificate was annexed.
You have taken a no objection from him.
No, my lord.
What happened to the advocate? Previous advocate?
Advocate was ill for this reason. He declared he will not be able to come to court.
So he gave a no objection to you.
Yes, my lord. Then Mr. Torun Kanti goes, handle the matter, take over the matter, and his married, one of the married daughter living in Rakha Mines came here and filed this application. For this reason, my lord.
No, not that. We are not on that. What happened
Yes,
to
my lord.
the
A change. We has transferred the bill. Applicant petitioner medical certificate, his wife medical certificate, and the advocate for the applicant petitioner medical certificate. It's annexed here with my lord. That's kindly see. For this reason, there was a delay, and they are unable to come to court to file this.
বড় মানুষ 70-75 বছর বয়সে আর্থ্রাইটিস ফার্থ্রাইটিস রয়েছে, অ্যাডভোকেটেরও সিভিয়ার প্রবলেম দেখছি। আদার সাইড কি সার্ভ করেছে, আদার সাইড ফেরত এসছে, বলছে যে অ্যাড্রেসে সার্ভ করেছে যে সেন্ড করেছে সার্ভিস রিপোর্ট ট্র্যাক। ও ইউ হ্যাভ নট অ্যানেক্সড দ্য ট্র্যাক রিপোর্ট? হোয়াট ইজ দ্য ট্র্যাক রিপোর্ট?
That report is
Not annexed. There is no track report here, only the postal receipt. দেখলেন?
track report. How can it be available if the envelope is not served? For this reason, no track
You have
report.
minimum, no, you don't have minimum idea about postal services, sir.
Postal receipt.
Track report is always available. That will be shown there. Have you tried to take a track report? Do you know the website of the postal services?
The postal receipt was annexed here with.
Postal receipt means you sent. We want a track report.
Track
What happened to
report
that service?
When the envelope is not served to the respondent.
Then that is shown in the track report. You don't have minimum idea. You are arguing. If it is not served, not delivered, that is shown in the track report. That is why a track report is required. What are you saying? How did you come to know, sir, that it was not delivered? You manage the postal peon. So then how did you know that it was not served?
The postal envelopes are here, minor.
So envelopes you have to, আপনি আপনাদের কাছে রেখে দিয়েছেন envelope.
I have given to envelope. ওতে postal receipt ছাঁটা আছে তো দেখুন তো।
ওখানে রেখে কি করছেন? Put it a part of it. This does not contain any copy.
Yes, madam. ওর ভেতর ছিল না, কাগজটা খুললেন নাকি? ওর ভেতর তো সব ভেতরে ছিল।
কেন কেটে দিয়েছেন?
না, আমি তো গোটা কমপ্লিট।
ভগবান, আমি কাঁধের নিয়ে মানে সত্যি
খুললে কি?
is ascertained, we have given you liberty to correct the cause title, carry out the correction as per this liberty, and then it will appear in the list.
For the appellant, opposite party, my the respondent number one. Last occasion was sought for accommodation for instruction upon the respondent number one, whether the execution is still pending or not. But lastly, the respondent number one hospitalized and he just discharged on day after.
No, what was the context of the case? This is against an eviction decree.
Eviction decree, along with the money decree for the enhanced rent. Now we deposited the decretal amount as well as we are paying 80,000 occupational charge from the date of the decree. That is not admitted.
That is pursuant to stay granted by this court.
Granted by this honorable court. Now this amount of 3,81,000 and odd that not have accrued some interest is lying with the Registrar General. Now they have filed this application because in the meantime it was agreed we have handed over possession. So now the only thing left is not this amount of money. We say, my lord, that the sum of rupees 3 lakhs interest-free security deposit was there in the agreement for lease. That is there. Plain they have admitted that has not been adjusted in the money decree. We only want adjustment of that amount.
This is your application.
This is their application for withdrawal of the money and not the decree of the disposal of the appeal in that.
So did you directly file any opposition to this?
No.
Mr. Banerjee, the exact adjustment you have to disclose. So give you a week's time, just show the adjustments and give a copy to them.
The affidavit has been filed to this application. Opposition has been filed by us.
In that you have disclosed that adjustment. This ground has been
Just
taken.
not that sum of 3 lakhs is lying with them as security deposit. That we have mentioned in our opposition.
No, with them, not with the registrar.
No, with them. At the time of the lease, 3 lakhs was paid to them, which was kept by them as security deposit.
That they have to return.
They have to return. That is to be adjusted from the amount deposited by us, which is lying before the Registrar General.
Acha. So they will get back the amount less than 3 lakhs.
Yes, that's 3 lakhs. That is our.
Yes, what do you say to this?
Yeah, I could take instruction.
No further time. Sorry. We'll dispose of the application. We granted you time on 6th of January. Today we are on 14th of January. 7 days.
Day before yesterday, he has just discharged. He is just 69 years old.
Day before yesterday, he was discharged. What is his instruction? Day before yesterday, he could take instruction.
His son took the phone. And
On the prayer of the respondent number 1, the matter is adjourned for till January 20, 2025.
In the meantime, the appellant will take out. I already stated in my affidavit. I have stated in my affidavit.
No, he did not take out anything. The application was dismissed for default.
I'm praying for password, my lord. Mr. Basu's
1 minute. No, the application is not listed today.
My lord, may I just make an humble prayer in the
It's item 5.
6.
Board 5 দেখাচ্ছে কেন 6 এ অ্যাপ্লিকেশন নেই কেন রেস্টোর হয়ে গেছে বলছেন তুমি
Subsequently, this order might, my lord, will kindly have respect this order. না ঠিক আছে দুটো আছে
হ্যাঁ রেস্টোর হয়ে গেছে তো
My lord,
which application is due to appear today
there is a stay application because the division bench directed that the matter will be heard without filing of paper books on the stay application.
that is can 1
Yeah, can one. Now they have taken out after this order, they have filed an affidavit in opposition. So I want to file a short reply. It's already ready.
can 1 টা লিস্টে দেননি কেন এই তো অর্ডার শিটই রয়েছে এই রেস্ট্রিকশন এইভাবে কিন্তু আমি কাজ করতে পারবো না আপনাদের নিয়ে আপনার they have,
I'm for the appellant, man.
and their application is for? Oh, they have filed an opposition.
They have filed an opposition. I want to file a short
Very well,
reply.
very
Within
well.
3 days, your lordship will hear out the matter.
Very well. Learned counsel for the appellant submits that previously the appeal was directed to be heard along with the application. Full stop. Next para. It is submitted that since a copy of an affidavit in opposition to the stay application bearing Can 1 of 2023 has been served on the appellant, comma, the appellant seeks to use a reply to the same, full stop, on the prayer of learned counsel for the appellant, comma, the time for filing reply is extended for a week from date.
Friday, I want the matter to be heard because they are proceeding in the lower court. I want it
Extended till January 17, 2025. Full stop, let the appeal and the application be listed
before 25th. They are
on January 20, 2025. Full stop. For the above purpose, comma, it is deemed that for the above purpose, Can 1 of 2023 is treated to be on the days list. Thank you very much. এটা অ্যাপিল অ্যাপ্লিকেশন একসঙ্গে আসবে 20 তারিখ। Why 2 weeks time? Your directions were already given on 6th of January. What is the application?
Application for specific performance.
So what is the necessity of reply? What major thing has this have they said in their opposition?
One thing, Millard. December 2024, Millard, government initiated proceeding for acquisition some portion of this shoot plot, Millard, for railway project, and for that, Millard, both the parties, Millard, Millard, out of court, Millard, amicably tried to settle the matter, Millard, and an agreement.
There has been a settlement.
Agreement prepared, but not yet finalized.
So we'll keep it in the February monthly list. On the prayer of the appellant, the time for filing reply is extended for a fortnight from date. Full stop. Learned counsel for the respondent submits that there has been a talk, there has been an ongoing effort of amicable settlement between the parties. Full stop. Next para. Accordingly, in order to enable the parties to arrive at a resolution, let the matter stand adjourned and be listed in the monthly list of February 2025. Lord, you file a reply in the meantime, and if there is a settlement, then we'll pass orders on.
Item number 8, this is my application.
Yes.
Is a matrimonial appeal.
This section 5 application?
No, my lord, stay.
Defective, it says section 5 was filed and allowed.
No, my lord, section 5.
Out of time it's stated. Section 5
my
not
lord,
filed.
I have to file section 5. I do,
Then you're moving an injunction application without
no,
pointing
that
out
is
to the
my
court.
mistake, my lord. I don't know, my lord. Just, I ought
Why
to,
did you mention the application at all?
because, my lord, I am in the impression that is within time. But, my lord, that is my mistake. I checked the record, my lord. That is my mistake, my lord.
Very well. Learned counsel for the appellant seeks time to file an application for condonation of delay in presenting the appeal. Full stop. Let the matter go out of the list for the present, with liberty to the appellant to mention any application for condonation of delay, comma, if filed in the meantime, comma, for inclusion in the list.
No,
Go out
may I
of the
check
list.
the
Yes, file একটু দেখতে দেবেন ওনাকে সাইড দিয়ে।
Appeal for the appellate matter, but appeal arising out of a probate proceeding, probate granted, appearing for the first time.
You are seeking for the first time.
For the first time, it's an application for stay injunction, not to encumber with the properties, my subject matter of.
With soft copy will grant an ad interim order. Stay we are not granting, Mr. Shamul, because of the present appeal has been preferred against the grant of a probate. Full stop. Next para. Upon being prima facie satisfied of the merits of the appeal, as well as that there is urgency in the matter and the balance of convenience and inconvenience and irreparable injury factors inure in favor of grant of injunction, comma, the respondents, all the respondents or plaintiff respondents?
Not all the respond, there are
The respondents are restrained by an order of injunction from selling, transferring, alienating, and or encumbering the suit property in favor of third parties and or changing the nature and character of the same till disposal of the application. Full stop. The appellant stroke petitioners shall serve copies of the application on all the respondents opposite parties, indicating that the application shall be listed for hearing in the monthly list of February 2025, when the appellant stroke petitioners shall file an affidavit of service to that effect. Thanks.
Lord, may I file the affidavit in reply?
Opposition?
No, we have filed opposition last location. A supplementary was also Lord filed. Lord, property Lord in Boubazar area, Lord.
Yes.
614 square feet on the third floor, Lord, without.
This is eviction.
Eviction.
Commercial tenancy.
Commercial
Lease, not tenancy.
Supplementary
The
affidavit.
condition of the house, Lord, is.
You have filed a separate reply to the opposition.
Yes, Lord, a reply is there. Composite reply, Lord, to
Right.
both.
Yes.
The issue is with respect to Lord for at this juncture, Lord.
Boubazar property.
Boubazar property, third floor without lift, 614 square feet, Lord, with lift. Without lift. Yeah,
Yes.
Lord, Lord. Then my instruction was without lift, but he says that it's
Without
with lift.
lift.
My instructions were without lift, but Lord, he says that it's with lift, Lord. Lord, I will proceed on that.
So third floor, what is the area?
614 square feet.
Commercial. You are using it commercially.
Page 10 of the supplementary affidavit.
Commercial, Lord, that's and I used to pay rent of Lord 6,570 square feet. That's the plain case also.
So rental value according to this is 39,900.
So that Lord, they have Lord made.
What is the business you are running there?
Lord, my business is of business carry on. Teacher office. Teacher office.
Or jewelry or something?
Not jewelry.
Yes, Mr. Bhattacharya, any whisper here? That what business they are running?
Export import.
Export import?
That's their office.
Of what?
I mean, they carry business of export import, but that is their office. That is their office space.
It's only an office space, Lord.
Yes, but from that only office space you are running export import business.
But export import these days.
If that office is not there, no, export import has a wide connotation.
Not a good Lord venture these days anymore.
Not a very, maybe a stigmatic venture in some senses, but not a good venture. Very good venture. Export import, whatever you export and whatever you import, we are not aware of that. But export import is always a good business.
But if it's export, then it's a good business. Import is not.
We don't know. Depending on the product. 40,000, 30, 39,000 is quite all right. Who was at third floor?
I was paying Lord third floor.
Whatever you are paying. 39,000 will grant 35,000.
PV Ganguly Street, 235 by
Lord,
prime area.
The road,
prime business area.
Lord, on the road, ground floor, understandable. Lord, third floor, nobody even sees that.
Page 9.
You are enjoying an administrative stay.
Yes, stays.
When was the decree passed?
28 March.
Lord, decree was
Last
passed
year.
on 20th of March 2024.
30,000.
Lord, I'm not.
You are prepared for more. You are prepared for more.
I was not in a situation to bargain with your Lordship. Lord, I
Then
must
don't.
not. Lord,
30,000 and the installment, the arrears by 3 installments.
Will it be possible, Lord? Lord,
Two?
Lord, somewhere in 2025, Lord. 3 times, my lord, the rent.
No, no. Starting from 40, you say 2025, so it's 30.
Now.
The question which has come up for consideration at the time of disposal of the stay application is the occupation charges which is required to be imposed on the appellant as a condition for a grant of stay of an eviction decree. Full stop. Next para. It transpires from the valuation reports and the documents annexed to the supplementary affidavit filed by the respondent that the rental value per month in the area in question comes to about rupees 39,000 per month. Full stop. Next para. Learned counsel for the appellant submits that the area of the premises is around
14 square feet,
614 square feet, and the premises is situated on the 3rd floor of the suit building. Full stop. However, comma, we find from the materials on record and the submission of parties that the property is situated on on Bipin Bihari Ganguly Street in Boubazar, comma, which is a prime commercial area of the city. Full stop. Moreover, comma, the appellant itself is running a business of import and export from the said premises and accordingly exploiting the same commercially. Full stop. Next para. As such, comma, we are of the opinion that on the basis of the materials on record before us, comma, monthly occupation charges of rupees 30,000 would be a considerably good estimate of the rental value which can be fetched if the property is rented out to a third party at the current juncture. Full stop. Accordingly, Can 1 of 2024 is disposed of by granting stay of execution has been levied.
Execution
By
number? Execution case number? আমি জানতাম না। ও বলছে।
But we will continue the interim order. By granting stay of operation of the impugned decree of eviction as well as stay of all further proceeding in any connected execution case, comma, if filed, comma, till disposal of the appeal, comma, subject to the appellant stroke petitioner paying occupation charges to the respondent at the rate of rupees 30,000 per month, comma, payable by the 10th day of each month. Full stop. The first of such payments for the month of February 2025 shall be paid within February 10, 2025 and thereafter by the 10th day of each succeeding month. Full stop. The arrear occupation charges at the same rate, comma, from the date of the impugned decree till the month of January 2025 shall be paid by 3 equal monthly installments. Full stop. The said payment shall be made directly to the respondent, comma, subject to final orders which may be passed at the time of disposal of the appeal. Full stop. Next para. It is made clear that the arrears shall be paid. The first of the arrear installment shall be paid by January 31, 2025 and thereafter by the end of each succeeding month. Full stop. Next para. In the event of default of any of such payments, comma, the interim order hereby granted shall stand automatically vacated without further reference to the court. Full stop. Next para. In view of the appearance of the respondent through the respondent's learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file informal paper books without comparing with the records within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty is granted to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Lord, only one thing, Lord, if they would supply me, Lord, the account number, if my Lord would be, Lord.
Very well. একটা লাইন যেখানে ওই ইন ভিউ অফ অ্যাপিয়ারেন্স বললাম যেখানে ক্যান সেন্টেন্স ওই সেন্টেন্সটা যেখানে শেষ হলো সেখানে একটা দি অ্যাবাভ পেমেন্টস শ্যাল বি মেড by online transfer directly to the bank account of the respondent, comma, the particulars of which shall be furnished by the respondent to the appellant, comma, through their respective learned advocates within January 17, 2025.
Great.
দেখে নিয়েছেন তো?
I'm appearing led by Mr. Tilak Mitra. One of his relative died, Lordship. He is not present in court today. Lordship, kindly.
Mr. Mujumdar, what do you say? When should he,
Adjourn the matter 1 week.
how close relative? How close a relative?
I don't know.
If not very close, then we'll keep it tomorrow.
Yeah.
He has left court.
1 week.
Mr. Mujumdar, in the meantime, you ascertain the proximity of the relation and we'll keep it next week. On the you are for the respondent. On the prayer of the on the prayer of the ESI corporation, let the matter stand adjourned till January 20, 2025.
It appear fairly at the top because the next returnable date is 27 before the I.
Applications we always take before the other matters. 12, yes. Have you served on the other side? Did you direct it to serve? Not served. First thing. So serve copies of both the applications together. We'll direct you to serve copies of both the application and the memorandum also. The app, pardon?
Maybe granted.
No, before section 5 is allowed, we cannot do that. Condonation has to be first. But we are directing you to serve all to expedite the matter. The appellant stroke petitioner shall serve copies of both the applications along with the memorandum of the appeal on the respondent, indicating that the applications shall be listed for hearing on January 27, 2025, when the appellant shall file an affidavit of service to that effect.
I'm for the Somnath Adhikari is appearing for the respondent, but he is engaged in my lord courtroom number 29.
Not a good ground.
Can it
Yes.
be my lord at 2 p.m. my lord?
No, no. Sorry. Not a
Then
good
my
ground.
lord permit me to.
Yes, yes. We are permitting. That is the precise purpose that you have told. Yes. What is the matter? Mr. Bhattacharya, what is the matter?
Section 1 can 1 is the section 5 applications, my lord.
What is the delay?
There has been a delay of 211 days, my lord. What has happened in this case, my lord? My lord, the order was, judgment was delivered by the 10th bench of the my lord, City Civil Court.
What is the nature of the decree?
Degree, my lord, suit for first positions and my lord, permanent injunctions.
They got the degree against you.
Yes. They are the defendants in the suit.
Yes. What is the reason for the delay?
My lord, delay, my lord, what has happened, my lord, challenging that order, my lord, they have preferred an appeal before the Chief Judge City Civil Court, my lord, which is not permissible, my lord. And I have annexed this order, my lord.
You have withdrawn that?
Yes, my lord. My lord,
But that was dismissed.
Dismissed since, my lord, lack of jurisdictions, my lord. On
When was it dismissed?
The 21st of November 2024, my lord.
And you filed this appeal?
Here, my lord.
Yes, here.
8th of December, my lord. After obtaining the certificate.
Yes, what do you say?
Section 5, my lord, I am not talking.
We find from the application for condonation of delay bearing can 1 of 2024 that the appellants had erroneously preferred an appeal against the impugned judgment and decree before the principal bench of the City Civil Court at Calcutta. Subsequently, the said appeal being dismissed for lack of jurisdiction on November 21, 2024, the present appeal has been preferred at the earliest thereafter in the month of December 2024. Next para. Upon hearing learned counsel, we are satisfied that sufficient cause for the delay has been shown. Full stop. Accordingly, can 1 of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 406 of 2024. Full stop. The said appeal be treated to be registered and admitted. Full stop. No order as to cost. Yes. What is the next application? This can 2 is for stay.
Stay applications, my lord.
You said it's an eviction degree.
No, my lord. My lord, they have filed an my lord, suit for recovery of khas possessions, my lord. But we have taken a plea in the written statement that we are the
Recovery of
tenant
first person is eviction.
My lord, that is under the specific relief act, my lord.
Maybe.
But my lord, it is the premise they have denied our my lord tenancy right, my lord. But although my lord, all the
No, their suit is under section 6.
Yeah.
106.
106. Yes, so 106 is what was your defense?
The defense is that we are the tenants, my lord.
Monthly tenants.
Yes.
Under the Rent Control Act.
No, erstwhile owner. Rajlokhi, my lord, was the erstwhile owner, my lord.
106 a notice is required only.
No notice, my lord. No notice. And my lord, if your lordship kindly takes pen to the judgment, my lord, once, my lord, kindly see, my lord, the internal page of the judgment, page 5, my lord.
Yes.
My lord. My lord, the issue number 5, thereafter the next paragraph, my lord. It is found that the defendant contested the case by filing written statement and also an additional written statement, but choose not to adduce any evidence. It is found that there are documents Exhibit 1, Exhibit 2, Exhibit 10, Exhibit 10A, from which it will appear that the plaintiffs are the owners of the suit property. Status of atonement have been communicated to the defendant. Therefore, my lord, when the plaintiff had, my lord, purchased the property, the atonement notice was served to the defendant, my lord. So therefore, if they wants to vacate the premises, my lord, they have to serve notice under section 106, my lord. That has not been done.
106 notice was not served.
No. Nowhere, my lord, your lordship will
The
find
case of the plaintiff was that, my lord, he was their predecessor in interest.
No,
of the
this is not
caretaker in the
not
property.
eviction on
Eviction on the ground of trespass. No, my lord,
Trespasser.
He was
a caretaker, the predecessor in interest of the appellants.
In the
Now, my
plain
lord,
case, they have stated that we are the, my lord, unauthorized
How
occupants.
do you deal with the atonement? It
My
was
lord,
atoned in their favor.
Therefore, my lord, the trespasser cannot lie.
One
my
minute,
lord.
one minute.
Yes.
Atonement exhibits are there.
my lord, if they are tenant, my lord, they have to produce some evidence to that effect, my lord.
If there is an atonement, isn't that sufficient prima facie evidence? And you have to rebut that relationship was severed.
A relationship was severe. He was a caretaker. He did not produce. He contested the suit, but he did not produce
No,
any
atonement
evidence.
was the atonement was communicated by you to the defendant. Was there any proof of atonement?
My lord,
Oh, from the evidence it was found he was a caretaker.
yes. My lord, he has to rebut the evidence by producing
That's
evidence.
the first step. It's the first step. So if you don't grant state, it will become infructuous. We can at least consider occupation charges for this. File an opposition, disclose what should. Can 2 of 2024 is taken up for hearing. Pushed up. The present appeal arises out of a suit for eviction of trespasser. Pushed up. Learned counsel for the appellants submits that the appellants are tenants in respect of the property and the tenancy was atoned in their favor, whereas learned counsel for the plaintiff's respondents controverts the same and argues that as per the finding of the learned trial judge, the appellants were mere caretakers of the property and did not have any tenancy right, nor did the appellants succeed to produce any document in favor of their alleged tenancy. Full stop. Next para. Be that as it may, since in a first appeal, both questions of law and fact are involved, we are of the opinion that unless stay of operation of the decree, you have put it into execution.
Yes.
What is the execution case number?
Case number, my lord, I got from the my lord, internet, my lord.
Is granted, the appeal shall be rendered infructuous. Push up next para. Accordingly, there shall be stay of operation of the impugned decree as well as all further proceedings of any connected execution case, if levied, till disposal of the application. Pushed up. The appellants shall file their affidavit in opposition disclosing the rental value which the subject property can fetch at the current juncture in its area of location. Full stop. Such affidavit in opposition shall be filed within a fortnight from date. Full stop. Reply if any shall be filed within a week thereafter. Full stop. The application shall be listed next for hearing on February 12, 2025. Full stop. It is made clear that the question of imposition of occupation charges as a condition for the stay granted is kept open for being decided finally at the time of disposal of the application. So when we impose the occupation charges, it will relate back to the date of the decree.
Great.
Well, I am for the appellant.
Appearing for the first time?
First time. My lord, kindly have a
What is the
short
defect?
list of dates, my lord.
What is the defect?
No defect, my lord. My lord,
Defective notice there. Let us see what is the defect.
my lord was passed an order or 2 times, my lord, directing the plaintiff to file an appeal before the appropriate bench, my lord. My lord, kindly come at page.
The name of defendant number 1, 3, 4, and 5 of the trial court do not find place in the cause title of the memo of appeal. Preamble of instant memo of appeal is bereft of the name of the learned judge of the trial court. First, remove the defects. Name of the learned trial judge has to be given in the preamble of the memo. And name of defendant numbers 1, 3, 4, and 5 are not parties to the appeal. How could you miss out those people? You have to remove the defects. Let us see who are 1, 3, 4, and 5. From the decree, let us see.
রেসপন্ডেন্ট আমরা পুরোটাই করেছি রেসপন্ডেন্ট নাম বাদ গেল থেকে বলছে অ্যাপিলে
No, not respondent. Defendant numbers 1, 3, 4, and 5 on. You are the defendant, some of the defendants. The other defendants had to be implemented as pro forma defendants, pro forma respondents. Probably that's why you have missed them. Correct the defects. We will give you a week. We'll keep it next week. It appears from the report of the additional stamp reporter dated January 9, 2025 that the appeal is defective on 2 counts. Full stop. First, comma, the name of defendant numbers 1, 3, 4, and 5 in the trial court do not find place in the cause title of the memorandum of appeal. And secondly, the preamble of the instant memo of appeal is bereft of the name of the learned trial judge. Full stop. The learned advocate for the appellant shall cure such defects within a week from date. Full stop. A report in that regard shall be prepared by the office and tagged with the main file. Upon such defects being cured, full stop, the application shall be listed next on January 27, 2025.
Well,
that apart, comma, this is against what? It's a decree.
No, my lord. My lord, identity model of injunction status quo. My lord, despite your lordship.
Identity model of status quo, how can there be a first appeal, regular first appeal?
My lord, order was passed, my lord,
Oh.
under order 39, rule 1 and 2
Oh.
application, my lord.
Moreover, the application shall be listed, jeta bollam ota kete din. We also find, thank you. We also find that the appeal has been preferred against an ad interim refusal of injunction.
No, not refusal, my lord.
Order of injunction.
Status
of ad interim order of status quo. However, comma, the same has been classified in the memorandum as a regular first appeal. Full stop. Necessary correction in that regard shall also be carried out by the learned advocate for the appellant during the course of this week. You have classified it as FMAT. Full stop. Next para. Necessary consequential corrections shall be carried out to the cause title and the preamble as well as the caption of the memo by the learned advocate for the appellant within the time as stipulated above, full stop. Thereafter, comma, the department shall reclassify the appeal under the proper number, full stop, liberty to the parties to mention the appeal for being included in the list under the heading Order 41, Rule 11 thereafter. It will not appear as an application. It has to be admitted formally. It's a misappeal. So 3 corrections, carry out those within a week. You can do it today also, today or tomorrow. Do that, inform the office, they'll give a report, reclassify, and then immediately after that mention, you take it under Order 41. You have to give documents to show that possession has been taken.
Yes, my lord. I am appearing on behalf of.
Just hand over those documents.
I am led by Mr. Mitro, my lord.
Yes, it's not difficult.
This is the.
You are Ms. Sadhu Khan?
Yes, my lord.
Very good. This is the bailiff's report or what?
Yes, my lord. This is the order disposed order along with bailiff report, my lord.
Order of the execution case.
Yes, my
Recording
lord.
satisfaction of it.
Yes, my lord. Order dated, my lord.
Yes. We'll keep this on record and dispose of the appeal as dismiss the appeal as infructuous. Not infructuous actually, because 144 is there. This is against an eviction decree.
This is against the rejection of Order 21.
Oh, acha, then it has become infructuous. So they were the judgment registers.
Yes.
None appears at the time of call for the appellant, which of it is seen from the order dated January 9, 2025, that on the said occasion also the appellant remained unrepresented. Full stop. Next para. Learned counsel appearing for the respondents stroke decree holders hands over photocopies of several documents, comma, including the order of the executing court recording satisfaction of the decree and the connected bailiff's report to indicate that possession of the property has been taken in due process of law by the decree holder stroke respondents in the meantime. Full stop. Next para. Since the appeal itself has been preferred against a deemed decree passed within the contemplation of Order 21, Rules 97 to 101 of the Code of Civil Procedure, comma, it is evident that the appellant has lost interest in view of the appeal being rendered infructuous. Full stop. Next para. Accordingly, FMA 249 of 2023 and CAN 1 of 2023 are dismissed as infructuous without an order to cost. The documents handed over today be kept on record. Thank you. Thank you, sir.
Item number 16, my lord, I appear for the appellant's petitioner.
Yes.
Lordship.
Is the microphone on? Please just check up.
Yes, lordship. Am I audible, my lord?
Yes.
The appellants before my lords are the plaintiffs in a suit for partition. This appeal is directed against an order of rejection of my application under Order 39, Rule 1 and 2.
Why was it refused?
It was refused on primarily on the ground that it is barred under Order 22, Rule 9, because there was a previous suit which was taken out by my predecessor in interest for injunction and declaration, not for partition also, lordship. No documents were produced to
But
such
declaration
effect.
of title. Your
That
share.
lordship we do not possess the plaint because it was taken out by my
We have to produce that, otherwise we cannot be
lordship.
satisfied.
Lordship, then
Difficulties because partition, yes, partition is a continuing cause of action.
cause of action.
But implicit in a decree for partition is your declaration of title also.
Lordship.
Because the preliminary decree will be declaration of your share,
Lordship.
including your title.
But Lord,
So if your title, if it's barred by 220, Order 20 Rule 9, then we cannot.
But partition till date has not been affected, and the order has been passed merely on the basis of the statements made in the written objection. But lordship, defendant number 2 has admitted that I am in joint possession, and it has also been recorded in the impugned order. May I just place a portion of the impugned order, my lord?
Have they admitted your title to the property?
They have admitted that we are in joint possession of the
Joint
property.
possession, maybe. Let us see the impugned order
Impugned
first.
order, lordship.
Oh, the order, the order of abatement of the previous plaint has
Nothing
not.
was produced.
Very well.
Nothing was produced.
We'll admit the appeal.
I'm deeply obliged.
There is no
my lord.
caveat.
No caveat, lordship.
কোনো এখানে আগের ইয়ে কিছু না প্রডিউস করলে তাহলে হচ্ছে ব্যয়ের কথা কি করে হবে? The present appeal has been preferred against the refusal of the plaintiff stroke appellant's the dismissal of the plaintiff stroke appellant's application for temporary injunction in connection with a suit for partition instituted by the appellants. Who's up next para? It is rightly argued by you and Ms. Sengupta.
Yes, my lord.
Don't include the name of Mr. Banerjee. Who is leading? Anybody leading you?
No, my lord.
It is submitted by Ms. Devjani Sengupta, learned counsel appearing for the appellants, that the learned trial judge proceeded on the presumption that a previous suit filed by the mother of the plaintiffs for declaration and injunction, which was registered as title suit number 1440 of 2013, was abated in view of the legal representatives of the plaintiff mother not being brought on record, full stop. Next para, as such, it was observed that the present suit is barred prima facie under order 22 rule 9 within bracket 1 of the code of civil procedure. Full stop. Next para, however, we find from the impugned order that the learned trial judge himself or herself that the learned trial judge himself recorded that the order of abatement or the pleadings of the previous suit have not been filed, full stop, in view of the plaintiff's appellants having denied the allegation of the bar under order 22 rule 9, and in the absence of the previous order or the plaint of the previous suit, we are prima facie satisfied that the learned trial judge erred in law and in fact in refusing injunction on such count alone. Full stop. Accordingly, the appeal is admitted and will be heard on the above ground as well as the other grounds taken in the memorandum of appeal. Full stop. The appellant shall serve. You don't have any application?
No, my lord.
No application?
I'd advise them to file, but they did not file any application. That is also.
Why didn't you file an application? Then what is the use of admitting this appeal? Liberty is granted to the appellants to file an application for injunction if the appellants so choose, and to mention the same for inclusion in the list.
Deeply obliged, my lord.
চলে গেছে তো, বেরিয়ে গেছে, ছেড়ে দিন। ইনজাংশন করলে তখন এই অ্যাপিল শুধু শুধু করা নিয়ে লাভ নেই। Yes, Mr.
But I filed a suit, Lord, seeking eviction of my learned friend's client on the ground, Lord, of that the lease had expired, and it was rather determined. Lord, the lease was determined. Now, Lord, the learned judge was pleased to, Lord,
expired or determined?
Lord, it was determined. Determined because it was determined by a notice 106. Now, Lord, the property was purchased in the year 1963 between, Lord, one gentleman, Lokhi Narayan Samanto, and my client, Subodh Kumar Samanto, the appellant before your lords.
Lokhi sold to you?
No, Lord, Lokhi Narayan.
Both of you purchased?
Yes. And in the year 2009, by dint of a solenama, the property was, Lord, partitioned between myself and Lokhi Narayan, Lord, Samanto. Now, Lord, that particular, Lord, the partition deed is, Lord, that is exit. Now, Lord, in the meantime, what happened on 16th of July 1980, Lord, my learned friend's client was, Lord, inducted as a lessee by an agreement to lease by, Lord, 3 persons who are the partners of, Lord, one Vivekananda oil mill in respect of, Lord, the suit property. Lord, the partners of the Vivekananda oil mill are Shambhunath Samanto, Sanot Samanto, and Subodh Samanto, my client.
All right.
Now, my lord, after my lord, the partition degree, my client was my lord, allocated my lord, this portion on which my lord, my learned friend's client, my lord, they operated the storeroom. My lord, they are WBSEDCL.
But what was the role of Vivekananda Oil Mill? I mean, they were the vendor initially to you.
No, my lord, they did not have. There was a my lord, these are all between my lord, the family members. They were running my lord, a oil mill. Where my lord, this particular property was my lord, owned by my client as well as Lokinaran being my lord, the predecessor of my lord, the other party.
But 2009, you entered into that Solenama.
Yes, that is for the purpose of the division of Lord the estate.
Yes, but you purchased the property when you said?
In 1963.
Oh, 63, right.
63. Lord,
All right, all right.
Subodh and Lokhi purchased the property.
Lokhi was also one of the partners, no?
No. Lord, Lokhi is possibly Lokhi.
Lokhi and Subodh amount to the same thing, the nomenclature.
Yes. Only
So they have some tie.
The gender differences.
No, Lokhi is probably a man also. I mean,
So here it is a man.
Yeah, but Lokhi Chele we use.
Lokhi Chele, yes.
Yes. So, but whether because otherwise it becomes complicated. Because anyway, what is an admitted, not admitted? I mean, your case is that there was a Solenama, Lokhi and Subodh became the owners of this portion.
Lordship.
Which regarding which the tenancy was granted.
Lordship.
So that portion fell in your portion.
Lordship.
Right.
Now, Lord, if your Lordship kindly comes to Lord, well, Lord, before your Lordship comes to the impugned order, Lord, the notice, Lord, that was issued in 2013, 10th of December 2013.
Yes.
And Lord, the notice were received both by defendant number 1 and defendant number 2. Defendant number 1 is the company, defendant number 2 is Lord, the office bearer.
All right.
Now, Lord, the suit was filed. My client gave evidence and there were 2 witnesses on behalf of Lord, the defendants. Lord, before I take your Lordship, Lord, to those witnesses' statement, Lord, I take your Lordship, Lord, to the judgment.
Why was it dismissed? Just give us...
Lord, because the learner just said that I could not prove my case.
The notice was exhibited.
That issue was Lord, held in my favor.
So you could not prove what? Your title?
Lord, that is Lord, the...
You was probably also confused like us. Because Vivekananda came in the wind.
Lord, that is only
Vivekananda came between. So we recently were commemorating Vivekananda, but he has come in between you also.
Yes. Lord, that portion is also Lord bit obscure. Lord, to be very honest,
that is to be so.
It doesn't transpire from Lord the document that how Vivekananda gave Lord that agreement.
Purchase deed of 1963 was produced. Who purchased that property?
Lord Subodh and Lokhi.
Oh, Subodh and Lokhi. Very
but so far as my Lord title to the property, Lord after Lord the 2009, that is undisputed.
Right.
Therefore, I am running a case that I am entitled to Lord the possession of the property as the owner thereof.
And you were one of the inductors also. I mean,
am one of
you
the
inducted
inductors
also
as a partner Lord of Vivekananda, overlooking that.
Very well. So should we go to the impugned judgment first?
Lordship.
Right.
Lordship will kind come to that. It starts from page 34 of the paper book.
Yes. Mr. Mujumdar is for the other side?
Yes.
All right. Yes. He has written 106 written all over his face. Scope is very limited, Mr. Mujumdar.
Lord, your Lordship will kindly, Lord, page 35.
35, yes.
35. Lord, your Lordship will briefly find, Lord, the inter alia, the plaintiff along with one Lokinaran Shamanto purchased the suit property from its erstwhile owners, namely Shohid Hashman Khan and Boshimansha Bibi, by a registered deed of sale numbered such and such 1963, inter alia, the joint possession of the suit property by the plaintiff and Lokinaran Shamanto advanced disadvantages. So the plaintiff filed a partition suit in this court numbered such and such, wherein by dint of a solenama, the plaintiff of this suit stood sole owner of the suit property. His name has been duly recorded in the LR ROR. Inter alia, the plaintiff entered into an agreement of monthly lease of the suit property and go down. And with the defendants, the monthly rent was fixed at rupees 7,536, but subsequently the rent was enhanced from time to time. Presently, the monthly rent is rupees 18,785 per month. Presently, the plaintiff intends to develop the suit property after demolishing the godown for his mercenary gain. The plaintiff issued a notice to quit dated 10/12/2013 under section 106 of the Transfer of Property Act, which notice defendant number 1 received on 13/12/2013 and defendant number 2 received on 11/12/2013, but the defendant, in spite of receiving such notice, did not vacate and hand over peaceful possession of the suit property to the plaintiff in trial. The aforesaid cause stirred the plaintiff to file the instant suit, wherein the plaintiff has prayed for a degree of eviction of WBACDCL, that is the defendant from the suit property, a degree of damages at the rate of ₹1,000 per diem, and from 29/12/2013 till the defendant handing over peaceful vacant possession of the suit property to the plaintiff, degree for cost and other relief. Defendants filed WS against the plaintiff case, in which the defendant denied most of the contents of the plaint. The following is a brief account of the alleged facts contained in the WS filed by the defendants. Inter alia, no notice was sent to the chairman and managing director WBACDCL, and inter alia, that there is no authority as secretary WBACDCL, Bidut Bhavan, Salt Lake, Kolkata 91. Inter alia, the suit property belonged to Mrs. Vivekananda Oil Mill, represented by its partners, namely Shambhunath Samanto, Sanat Kumar Samanto, and the plaintiff, who let out the suit premises to West Bengal State Electricity, presently converted to WBACDCL. In Kerala, there was a lease agreement between WBACB and Vivekananda Oil Mill on 16 July 1980. In Kerala, presently, WBACDCL has been possessing the suit property as their Bardhaman zonal store. On inter alia payment of rent, inter alia, the lease period got extended up to April 2015, and in view of a power of attorney, Sanat Kumar Samanto received rent on behalf of himself and other partners inter alia after the lapse of 30 years from induction. The plaintiff is now claiming to be the sole owners of the suit property, which is being used as Bardhaman zonal store. The plaintiff has stopped receiving rent. WBACDCL is ready to execute a fresh lease agreement. Inter alia, the plaintiff have full knowledge of the fact that WBACDCL is evicted. The work of distribution, circulation, and maintenance of electricity in the entire district will be gravely hampered, has filed the instant suit. During trial, the plaintiff, namely Subodh Kumar Samanto, produced himself as PW1, and one Povitra Mohan Pradhan, one Priyobrata Mondal produced themselves as DW1 and 2. It is from the evidence of PW1 that a certified copy of registered sale deed number such as such, a certified copy of final degree with Solenama in suit number 2008, a certified copy of LR ROR being Khatian number, tax receipt, one photocopy of letter being number such and such, one letter dated such and such with postal receipt, another notice dated such and such with postal receipt, a letter dated such and such were marked Exhibit 1 with objection, 2, 3, 4, 5 with objection, 6 series, 7 series, 8 with objection. It is from the evidence of DW1 that a photocopy of document dated 16 July 1980 was marked Exhibit A. This is not that agreement of lease. In my case, it was not a photocopy produced that was objected to. In their case, not pursuant to order of this court, this was marked as exhibit, although this is not a photocopy of not the is a secondary not evidence which was admitted.
But both of you agree on that?
We agree on that.
Right.
Number issue number 1, that was decided in favor of my client. That is at page 37.
Yes, yes.
Then issue number 3, which is whether the notice has been duly served. But that has also been decided in favor of my client, that your lordship will find at page 39. I'm sorry, it is 40.
40, yes.
40. However, due to the aforestated reason, in this issue, it can be held that the notice has been duly served under section 106 of the Transfer of Property Act.
Right.
Now, comes issue number 2 and 4. I'll read the issues before.
Yes.
The issues. The 2 is the plaintiff entitled to get a degree of recovery of khas possession, and whether the defendants are liable to be evicted. 2 and 4. Issue number 2 and 4 are taken up for discussion together for reason of convenience and brevity. The plaintiff, namely Subodh Samanto, filed affidavit in chief in which he corroborated the plaint case, and such affidavit in chief he tendered in court as PW1. PW1 stated in his cross-examination in trial that the suit property was taken on rent for using the same as a godown of WBACB in 1980, and that an agreement was executed between him and WBACB on 16/7/1980, and that in trial Mrs. Vivekananda Oil Mill was the lessor and WBACB was the lessee, and Mrs. Vivekananda Oil Mill was a partnership firm, and in trial Shamiran Samanto, Shambhunath, that is Shambhunath Samanto, is the father of the plaintiff. and Shanot Samanto and the plaintiff were the partners of that firm at that time of execution of the lease agreement. PW1 further stated in his cross-examination in Trala that he became the absolute owner of the suit property in the year 2009, and that after he became the owner of the suit property, no new lease agreement was executed between himself and electricity authority. Inter alia, from the evidence of PW1, some documents were marked Exhibit 1 after objection to A after objection. One Povitra Mohan Pradhan from the side of the defendant produced himself as DW1 and filed affidavit in chief in which he corroborated the defendant's case as per WS. DW1 tendered the said affidavit in chief in court as DW1. DW1 stated in his affidavit in chief in Trala that the suit property originally belonged to Vivekananda Oil Mill, represented by its partners, namely Shambhunath Samanto, Sanat Kumar Samanto, Subodh Samanto, who subsequently let out the same to WBACB, now WBACDCL, and in Trala, a lease agreement was executed by and between the WBACB and Messrs. Vivekananda Oil Mill, represented by the said three partners on such and such date. DW1 further stated in his affidavit in chief in Trala that since induction of the said lease period is being extended from time to time, as such, the said lease period has been extended up to 13/5/2015 and up to April 2015 in view of the power of attorney. Sanat Kumar Samanto for himself and on behalf of other partners has received the said rent all along, and that the last rent has been enhanced at rupees 18,785, and after long 30 years of induction, the present plaintiff has come with a letter claiming to be the sole owner of the suit premises used by the defendants. I pause here for a moment to say this contention of the defendants were not proved. They only came up with Exhibit A, which is not the photocopy of the agreement, not about that the tendering of that rent, which they say to one of the erstwhile partners. And has come with a letter claiming a sole owner of the used by the defendants. DW1 has in Trala denied the plaintiff to be the sole owner of the suit property in his affidavit in chief. DW1 stated in his cross-examination in Trala that in 2014, at the time of institution of the suit, he was manager HR at Bankura Regional Office of WBSCDCL. DW1 in Trala admitted in his cross-examination that the WS has been filed on behalf of the defendant as written over there, which may mean that it has been filed on behalf of all the defendants. DW1 further stated in his cross-examination that it is also written in the affidavit portion of the written statement that the same has been filed on behalf of all the defendants. DW1 also stated in his cross-examination in Prala that when the lease deed was executed in 1980, he did not join service and he does not have any personal knowledge about the lease deed as he has only gone through the same. It is from the evidence of DW1 that as per the order of the Honorable High Court at Calcutta in FMAD number 355 of 2021 with can such and such dated such and such on consent of both parties, a photocopy of the document dated 16 July was marked Exhibit A. The defendants of this suit produced one Priyabrata Mondal as DW2 in this suit. The said witness, namely Priyabrata, filed affidavit in chief in the suit, which is stated in Trala that the apex authority.
Your Lordship. Yes, we just come back. And
I'll continue.
6-7 minutes and come. Yes.
Lord, I was at page 41.
Yes.
Lord, the second paragraph about not the fourth line.
Right.
No, Lord, about seventh line. DW2
Yes.
tendered the affidavit in chief in court as DW2. DW2 admitted in his cross-examination in trial that he has no personal knowledge other than the information provided to him by his learned advocate and perusal of documents, and that in trial he cannot tell the name of the company secretary of WBACDCL, and that in trial he cannot remember whether the secretary of WBACDCL received the notice on 13/12/2013 or not. DW2 in trial admitted in his cross-examination that what he has stated in his evidence are not there in the pleading.
DW2's memory is like me. He had forgotten everything and went there in the witness box. Yes.
The exhibit 1 is a certified copy of deed number 1782 of 1968, from where it is found that one Lokhinarayan Samanto and the plaintiff purchased.
Should it be 63?
But it should be 63.
I think so, yes. Because it was previously stated also by the court.
Yes, Lord, it is.
Anyway,
in fact, Lord, it is exhibited, Lord.
Yes, yes, yes.
I'll give your Lordship, Lord, the page number.
Right.
It is 63. From where it is found that one Lokhinarayan Samanto and the plaintiff purchased 5 bighas, 15 kata, 4 chitaks of property in Sud Dag. Lord, I will explain before your Lordship about the Sud Dag. There's one discrepancy. I'll say that, Lord, whilst I'm Lord, giving reference to Lord the partition deed as well as the sale deed. I'll just give you a Lordship. Lord, in my schedule to the plaint, I've given Lord 2 Sud Dag numbers, 995 or 996.
Yes.
But 995 should be omitted because that falls within the share of Lokhinara. In the event, Lord, I get a degree.
But does the tenancy, the tenancy is spread over both?
Lord, tenancy is spread over, Lord, Lord, I should say.
If that be so, then can you split the tenancy?
No, it is 996. It is. I'll show Lord the.
Yes, yes, yes.
Lord, the exhibit 2 is the certified copy of final degree along with the solenama in title suit number such and such, from where it is found that co-schedule of the solenama in the said suit was decreed in favor of the plaintiff of this suit. It is found from exhibit 2 that the plaintiff acquired 96.82 shatok, that is 42175 square feet property in the Sud Dag, and one Lokhinarayan Samanto acquired the same amount of property in Sud Dag. The exhibit 3 is the certified copy of LR Khotian in the name of the plaintiff, which referred to LR Sud Dag number, that is 995-996. Exhibit 4 is the red receipt of Dag number 996. Exhibit 5 is a letter dated 2/12/2013 bearing reference number such and such by Assistant Manager Store officiating Bardhaman Zonal Store WBACDCL to the Additional General Manager F&A Bardhaman D Zone WBACDCL Spandan Complex such and such, wherein it is found in Trala that Assistant Manager Store enclosed a rental bill for November 2013 submitted by Shonot Samanto, which bill as per the said letter has been stated to be duly certified by Assistant Manager Store in Trala for payment. Exhibit 6 series and 7 series have been already discussed in issue number 3, hence to eliminate reiteration of the same, this court abstains from rediscussing Exhibit 6 series and 7 series. Exhibit 8 is a copy of letter dated 1/4/2015 by Zonal Manager, addressed to the plaintiff in reference to Exhibit 7, wherein the Zonal Manager inter alia requested the plaintiff to submit related legal document court order in support of the plaintiff's allegation within a time span of 3 days from the date of issuing the said letter, in default of which the WBACDCL would have to release the rent in favor of Shanot Kumar Samant. Exhibit A is a photocopy of the lease deed dated 16 July 1980. The lease deed appears to be between Messrs. Vivekananda Oil Mill and WBACD. Undoubtedly, Exhibit A is an admitted document. Therefore, this court is not delving into the legal provision envisaged under Section 107 of the Transfer of Property Act. Learned advocate for the defendant number 2 has submitted in this written argument the discrepancies between the pleading and the documentary evidence, the pleading and oral evidence of the documentary evidence. Learned advocate for defendant number 2 has relied on a ruling that is such and such. Learned advocate for defendant number 2 also tried to add to this defense in his written argument by referring to the alleged conduct of the plaintiff of receiving rent of the suit property even after service of notice to the defendant under section 106 of the Transfer of Property Act, and has stated in his argument that since the lease rent was paid up to April 2015 and the notice under section 106 of the Transfer of Property Act was issued on 10/12/2013, it implies that the plaintiff has received the monthly rent up to 2015 so far as section 106 of the Transfer of Property Act. The tenancy of the suit property has not been determined. Learned advocate for the plaintiff battered the defense taken by learned advocate for defendant number 2 by relying on 2 rulings. Not the rulings are quoted. Learned advocate for the plaintiff stressed on the said 2 ruling and asserted in his argument that mere acceptance of rent does not mean that the plaintiff's notice under section 106 of the Transfer of Property Act loses effect and the plaintiff cannot file an eviction suit. But then the learned judge comes to a finding. The legal question here is as to whether the service of notice under section 106 of the Transfer of Property Act is adequate to evict the defendant from the suit property or not. It is clear from Exhibit 2 that the plaintiff is the owner of 96.82 shatok or 42,175 square feet of property in the suit. The Exhibit 3 clearly proves that the plaintiff has possession of some property in suit LR Dag. However, the service of notice under section 106 of the Transfer of Property Act does not itself usher a right on the plaintiff to evict the defendant from the suit property, for neither the plaintiff nor the defendants have produced any rent receipt to prove that the plaintiff is the landlord and the defendants are the tenants of the plaintiff. More so, when the defendants have averred in their Exhibit 8 that Shanot Kumar Samanto has received rent for Vivekananda oil mill. In fact, Exhibit 3 and 8 clearly prove that in view of Exhibit A, once Shanot Kumar Samanto used to take rent from the defendants, as against the said documentary evidence, the plaintiff has not produced any cogent evidence to prove that the defendants are tenants of the plaintiff or the defendants used to pay rent to the plaintiff, and not once Shanot Kumar Samanto as tenant and landlord. Since Shanot Kumar Samanto has been alleged by the defendants to be the person accepting rent of the suit property, Shanot Kumar Samanto is a necessary party to the suit. Hence, the plaintiff should have made Shanot Kumar Samanto a party to the suit to disprove the defense case and Exhibit 3 and 8. However, the plaintiff, as appears from the case record, has been negligent enough not to add the said Shanot Kumar Samanto as a party to the suit. Thus, this suit suffers from defect of necessary party 1. This is one of the findings. To add to the aforesaid lacunae, in the plaintiff's case, the case record also reveals that the plaintiff has neither got an inspection commission done, nor has the plaintiff produced any document to show that the defendants are occupying his portion of the suit property as per Exhibit 2. The learned advocate for the plaintiff produced inter alia 2 rulings that they are not such and such, bearing such and such. The Honorable Supreme Court was pleased to hold that mere acceptance of rent by landlord after expiry of period of lease would not amount to waiver of termination of lease. The ratio of Shanti Prasad such and such, mere acceptance of rent after expiry of lease period for subsequent months in which the lease continued to occupy the lease premises could not be said to be a conduct signifying assent to continuance of lease. Renewal clause in the lease agreement fell within expression agreement to the contrary, used in section 116 of the Act. In the face of the specific clauses for seeking renewal, there would not be implied renewal by holding over on mere acceptance of the rent offered by the lessee. Now, Exhibit A clearly shows that there was no renewal clause in the lease agreement contained in Exhibit A on which the suit stands. In fact, the rulings placed by the learned advocate for the plaintiff are not applicable to the facts and circumstances of this case because the locus standi of the plaintiff, in other words, the landlord and tenant relationship as alleged by the plaintiff could not be proved by the plaintiff. Learned advocate for the defendant number 2 cited a ruling bearing cause title Ramesh Kumar and another versus Pururam and another. However, the facts of the said ruling contained in the case appear to be different inasmuch as inter alia concerns an arbitration act of 1940 and other agreement. Due to the aforesaid reasons, this court is left with no other option than to hold that the plaintiff has not been able to prove his case. Evicted and the plaintiff is not entitled to a degree as prayed for. To summarize the decision.
Shanot non-joinder and lessor-lessee relationship not proved.
Lordship, and no commission.
No,
That is,
commission
that,
is,
that is another.
yes, no commission also. The,
Neither
to
got an
show that
inspection commission
occupant-
done, nor has the produced any document.
Yes.
Now, my lord, I take your lordship, my lord, one by one. My lord, the evidences are, my lord, not very German because these are all exhibited documents.
Mr. Mukherjee, you can also show us that a suit can be maintainable on the basis of 106 because the language of 106 is lesser.
But
105 defines lesser as the person who entered into the transaction. If you can show that a landlord can also maintain a suit, the owner can also come within the purview of lesser, then you have a case. Otherwise, also anyway, you proceed in your own way.
Lord, to take it, Lord, I'll just in a different perspective. Lord, even if I was, Lord, taken to be, Lord, a person who is inducting through, Lord, Vivekananda Oil Mill, I was also, Lord, a signatory to that agreement.
Yes,
It
but
is
if
not
you,
that I'm a stranger.
but Vivekananda Oil Mill has been named as the lesser in the agreement.
Yes, of which, Lord, 3 partners have signed on behalf.
Partnership is not exactly, I mean, it's not a juristic
That
entity.
document is, Lord, before the court.
All right.
I'll place before.
Exhibit A,
my lord.
yes.
Now, Lord, kindly come to, Lord, the exhibit 1, the certified copy of the registered sale, did not, which is at page.
Probably that is not disputed. I mean, that there will be no dispute.
No,
to
that is not disputed. I am only, Lord, referring to the DAG number, Lord, to show, Lord, which of.
Yes, yes.
I'll be very brief.
No, please.
Lord, kindly come to, Lord, internal page 3. The part 2.
Yes, yes. Part 2.
DAG number 753.
Right.
The area is mentioned 5 biga, 15 cutters, 4 chitaks. These are joint purchase.
That has become LR DAG numbers 995.
Yes, that is, Lord, I'll by virtue of Lord, the final degree in the Solenama, your lordship will find at internal page 8. Page 8.
Yes, page 8.
Lord Subodh Kumar Samanto, he gets, Lord, 42,175 in current DAG number, that is LR DAG number 996. RS DAG number is 753. And Lord Lokhi Narayan, he gets, Lord, 995, page 9.
Yes.
The areas are same. Now, Lord, there is a page 10, Lord, the map appended to, Lord, the Solenama, Lord. Then thereafter, Lord, the rent receipt, the mutations, those are done in respect of the properties. Then, Lord, the second last page.
And your suit schedule is comprised of 753 LR plot numbers both.
996.
Both. Yes.
Both.
Yes.
Plinta bar করে রাখ। Plinter ওই পাতাটা page 10.
Yes, we have
part
seen
1.
that.
Part 1.
We have seen that.
Then, Lord, kindly come to page 29. But rather, Lord, I will, Lord, start from, Lord, page 24.
Yes, because the names of the.
Yes. Lord, this is on 16th of July between Messrs. Vivekananda Oil Mill, hereinafter referred to as the lessor, which expressions shall, unless excluded by or repugnant to the context, include its successor or successors and the partners or partners for the time being of the said firm and their respective heirs, executors, administrators, representatives, assigns.
So includes partner or partners.
Yes, Lord, it is an inclusive definition of one part. And West Bengal State Electricity Board, Lord, having such and such, Lord, that is the other part.
No, the one important thing is found here that lessor includes not only the partnership firm, but its current partner or partners also. Partner or partners for the time being.
Lordship.
And the heir successors, that is the heir succession clause.
Lordship.
But importantly, it's mentioned the current partners are also within the fold of the lessor includes them also.
Lordship. Lordship. But the definition, as it rightly pointed out, Lord, it is a very inclusive definition.
Yes, including its current partners also.
Assigns, representatives, whoever.
Yes.
Now, my lord, the preamble, the lessor is seized and possessed of or otherwise well and sufficiently entitled to all those several pieces or parcels of land, the premises of formerly Vivekananda Oil Mill, together with its godown structures erected thereon or part thereof situated at Bardhaman Sodorghat Road, Post Office Bardhaman in the district of such and such, particularly described in the schedule hereunder written, delineated such and such, collectively referred to as the premises. Then, Lord, the lessor had agreed to grant and the lessee had agreed to take on demised premises for a term of 5 years, and commencing from such and such, the possession of the said premises at a monthly rent reckoned at the rate of 48 paisa per square feet of covered space, which comes to such and such square feet, and 12 paisa per square feet of open space measuring to 33.400 square feet. Thus, total rental stands at rupees such and such. Upon the why I place this, Lord, your lordship will find, Lord, the amount of space, Lord, that is agreed here, because 42,175 is, Lord, the allocation of each of the parties. The open upon the treaty of the proposed demise, it was further agreed by and between the lessor and the lessee will pay the monthly rental charges in the following month after the claim is preferred to the lessor through bill in triplicate drawn in favor of the senior accounts officer, office of the material controller, and duly certified by the officer in charge of Bardhaman Regional Store. The payment will be made by account pay check in favor of the lessor. Upon the actual measurement, it was found that the said premises was comprised of 7,350 square feet of covered room, godowns and structures, and 33,400 square feet, 33,400 square feet of open space therein.
Oh, but the tenancy is comprised of plot that number 996 only, which has fallen in your premises.
That is that your lordship will find in the schedule.
Yes, schedule says 996 only.
Yes.
So not that you are splitting the tenancy, it's spread over 995.
And it is not only extending to 40,750 square feet.
Which is your part also in 996.
Yes, and it is not, there is a remaining portion which I own it, and that is not
Yes,
part of the.
this is within your
within my
total area and totally confined to 996.
Lordship. Now, the term was, initial term was, for 5 years at internal page 3, first clause.
Yes.
Then, last clause of page 26, internal page 3, that lessor hereby appoints Sri Shanot Kumar Samanto to be their agent in the matter of realizing bills and making correspondence with the lessee, and the lessor shall be bound to confirm all the acts and deeds done by said Sri Shanot Kumar Samanto.
So Shanot was an agent. He collected on behalf of the lessors.
He was a partner also, I believe.
He was a partner, but that gives an important boost to your case.
That is that.
He was not the sole lessor.
No, after all, I am the owner in respect of the property. Now, if somebody has given the lease, it might be an arrangement between the parties that this property has been given on lease and they have taken on lease. Now, it is not such that that because of the entire partnership who are not the owners, they will come and seek the recovery of possession, because the property has never wasted to the partnership firm.
But then you also have to show that the term lessor in 106 includes owner.
Includes owner.
Only that.
Lordship.
And there are other things in your favor also. We are putting this openly because Mr. Majumdar will answer.
106 notice that has been served.
Exhibited.
Now, they do not have a defense to against the 106 notice.
Your locus standi is the
my locus standi. Now, the learned just said that I do not have my locus standi. My locus standi was proved by Exhibit 1 and as well as Exhibit 2, the partition deed. So far as the ownership is concerned.
So far as the ownership, yes.
Ownership is concerned.
Yes.
Now, the question is whether as an owner I am entitled to recover possession of my own property or not.
Yes.
But on a simple reasoning, not that, not even without going that whether it is governed under the Transfer of Property Act or not. But under the specific relief act, I am entitled to even seek recovery of possession.
Hmm.
Page 29, internal 6, internal page 6. But your lordship will find, Lord, that the schedule that the divided demarcated portion of the go down office accommodation by measurement and area 58 katas 3 chatas.
All pertaining to 996.
All pertaining to comprised of dag number 996 such and such.
But RS plot has been wrongly mentioned as 996, 753 old. It should be LR plot. Page 33rd line.
This is not 753 old.
Yes, RS plot. It is stated page 33rd line. RS plot 996, 753 old. It should be LR plot.
LR plot
996, 753
yes,
old.
Yes,
Whatever.
Yes. And municipal holding number such and such, and more particularly delineated in the map. Lord, the map I don't find, Lord, is part of. But map ta nahi. Are eighta sathe map ta nahi. What is Solenamar map?
Yes. Right.
Transfer forward. But your lordship will kindly transfer of property.
Yes. আচ্ছা নিয়েছি নিয়েছি
Lord,
আপনার ওখানে দেওয়া আছে
Lord,
ওনাকে বল
get
Oh,
up.
হ্যাঁ দু কপি করানো হয়নি দুটো কি করানো
Lord, in 100, I'm sorry.
105 and 106.
105, lesser defined, lease defined, the lesser, leasee, premium and rent defined, that portion.
Transferor is the lesser.
Transferor is called the lesser. And Lord, the transferee is called, the price is called such and such.
Yes. The transferor of the right to enjoy property, that is the lease.
That is the lease.
And 106 says that terminable on the part of either lessor or lessee. So
Correct.
lessor, the same expression is used.
The Lord, all through your lordship will find, Lord, in the particular this chapter, which chapter 5, Lord, which governs, Lord, the leases, Lord, the word lessor has been used.
Yes.
Lord, even 108, Lord,
Everywhere.
the rights and liabilities of the lessor and lessee.
Everywhere. Entirely.
Everywhere.
Entirely. Taking a strict view, owner has not been used here.
Owner has not been used
In
here.
the-
But Lord, the question here is that if a person is not the owner or a person who has not been vested with the power to give a lease, but there can be two circumstances. Suppose, Lord, I take the property in a case of a concurrent lease from somebody. Lord, the parent document gives me right to give it on lease to another person as
Yes.
a sublessee.
Then also you can get
I become, Lord, a lessor, although I'm not the owner of the property.
you derive your rights from the owner.
Yes. So, Lord, what that is to be seen here is, Lord, who has a right to recover.
Yes.
In the case of a default or even in a case of a determination of a lease, the person who has a right to recover possession of the property. whatever may not in the statute, the definition of the lease is, it contemplates certain other situations also. So, blood, in this particular case, blood, it is no doubt not the even the learned trial court held that I am the owner.
Yes.
The specific portion.
Right.
Only doubted, Lord, that whether it has been determined or not. The determination is by 106 notice.
Which has to be by a lesser.
Which has to be by the lesser.
Which the court says you are not the lesser.
I am not the lesser. But in this particular case, Lord, I am the owner of the property.
Yes, you are the owner.
And Lord, I was the signatory. That is not the. It is not a case, Lord, that I am a stranger to Lord the deed of lease.
You have two or three Easter eggs for you in the lease deed also, Mr. Mukher. One Easter egg is the hidden things. One is that the definition of lesser says Vivekananda Oil Mill, a partnership firm, including other things apart, the partner or partners, the current partners. So partner has been brought within the fold of that definition of lesser in the lease deed itself. Second, you were a signatory. And third is that this Sonot was appointed as an agent. So they have taken a plea that all along Sonot was taking the issuing the rent receipts. So that may be taken care of subject to what they say. So these three things, even from the lease deed, go in your favor apparently.
And Lord, the other thing is that Lord, it has not been proved before the court that Lord Vivekananda Oil Mill was the owner of the property. Although Lord, there was it says that
it's the lesser.
There was a oil mill, but now that the land is being leased out.
Yes, in this they say, but in the lease deed they say somewhere they say belongs to premises of formerly Vivekananda Oil Mill.
Yes.
So premises of
First clause, the lesser is seized and possessed of otherwise well and sufficiently entitled to all these several pieces or parcels of land, the premises of formerly Vivekananda Oil Mill, together with the godown structure erected thereon, or on part thereof situated at Bardhaman such and such.
So formerly Vivekananda Oil, it still is Vivekananda Oil Mill.
So Vivekananda Oil Mill was there at one point of time. It was a family business between the brothers.
No, but the lesser itself is Vivekananda. At the time of the lease being granted,
yes, it was
Vivekananda Oil Mill is the lesser.
It was in the name of Vivekananda.
So why is it said that other formerly Vivekananda Oil Mill?
In that particular land,
perhaps subject to correction by Mr.
It was not a partnership.
No, it was definitely a partnership. But my lord, perhaps the intention of the maker of the instrument was that Vivekananda Oil Mill, as an oil mill, was it not in operation?
There was formerly at that place
That
an
is the
oil
only
mill
construction.
was there.
Perhaps that may be the only construction.
There's no oil mill, but Vivekananda.
There was an oil mill there. Now it is a go down and all this.
It was not in operation.
Right. Right.
Number Q, 108Q. Then again, Lord, the definition that put the lesser into possession of the property on the determination of the lease. 108Q.
Everything revolves around lesser. Yes. So your argument basically, Mr. Mukherjee, is twofold. One is that the owner can always evict.
The owner is not in this particular case, Lord, within the definition of a lesser, Lord, owner is included.
Yes. All right. So that is the first argument.
Lord.
All right.
Now, Lord, here, Lord, the owner, he has terminated, Lord, by issuance of the notice 106.
You state that as a general proposition, that lesser includes an owner also.
Includes in this as a general proposition, yes. In particular propositions, Lord, as I cited, Lord, about Lord, the concurrent leases or subleases. in a case of sublease,
Yes.
when there is a permitted sublease, then would I get a lease with a permission that I can sublease to somebody?
But whoever grants the lease has to have a right in the property, which has to be derived from the owner.
Yes. Therefore, owner is not the paramount title holder of the property, who has a right to settle the property as he likes.
It's a
Here
very,
in the-
very interesting argument. Yes.
and here in this case, why you have a lease?
Right.
Why I say this? If your lordship kindly come to section 109. If the lessor transfer,
Yes, yes.
If the lessor transfers the property leased, or any part thereof, or any part of his interest therein, the transferee in the absence of the contract to the contrary shall possess all the right. And if the lessee so elects, he is subject to all the liabilities of the lessor as the property or part thereof transferred, so long as he is the owner of it. So it
Yes. All right. So long as he is the owner of it, he may not be an owner of it also.
That is the reason that it gives the primacy to the ownership of the property for the purpose of the right of the lessor's transfer. So it is only the lesser transferee who gets the right of ownership if the lessor is the owner of the property. If the lessor transfers the property leased, or any part thereof, or any part of his interest therein, this is a question of interest. First is transfers the property leased, or transfers any of his interest. The transferee in the absence of a contract to the contrary shall possess all the rights, and if the lessee so elects, be subject to all the liabilities of the lessor as to the property or part transferred, so long as he is the owner of it. Meaning thereby the transferee gets whatever the right that the lessor as a owner has.
But this also contemplates a situation, the contrary situation, where the lessor is not the owner, but transfers. Then
that is
this
the
right does.
interest portion.
That is the
interest portion.
Yes.
That is or any part of his interest therein.
Yes. Yes. Right. Good.
Excepting this, Lord, we don't find anything, Lord, subject to correction by my learned friend,
owner,
and even your lordship, Lord, that there is, Lord, any other, Lord, the sections which confer any link between, Lord, the ownership of a particular immovable property with that of, Lord, a lessor. So, Lord, my argument is based upon, Lord, the provisions in section 109. And Lord, 111, determination of lease, H, Lord, it talks about on the expiration of a notice to determine the lease or to quit, or of intention to quit the property leased duly given by one party to the other. That takes care of not 106. Although the 106 language is not lesser and lessee.
And we can also contemplate a situation probably Samkaji where a sublease is given. The tenure of the main lease was say 20 years, sublease is given for the remaining period or whatever. When the period of the main lease expires, the owner can always evict the lessor and along with him the subtenant also.
Lordship.
So owner's rights cannot be curtailed altogether. I mean, in that sense,
Owner
because
is
in
the
that
paramount
event,
title holder.
paramount title in that event, owner by getting an eviction against his tenant, his lessee, also gets an eviction against the sublessee.
Same
Because
in the case of a tenancy. In
tenancy also has same.
Subtenancy.
In case of a subtenancy only, where there is a subtenancy, and if the tenure is expired, whatever incidents befall the main tenant, that also attends the subtenant.
That percolates to the subtenant.
Percolates to the subtenant. So therefore, the owner gets those rights against the subtenant also by default. Owner's rights cannot be closed altogether. I mean,
it cannot be that way. Otherwise, he has to go fight a suit, seek eviction on the ground that they are the trespasser.
Yes, vis-a-vis him.
Because otherwise,
yes,
because the Vivekananda is not the owner in respect of the property. There is no even a privity to show before the.
There is nothing to show Vivekananda oil mill was the owner. Very good. Very good. So anything else?
Yes. So far as the definition of transfer of property, it doesn't give much of a light on the argument that I am trying to make. This is a general definition.
Does not.
Does not. I'll try to assist your lordship. If I can get any judgments, I can give it with a copy to my learned friend. Accepting that I link up 109.
Yes.
I do not have any other thing to show before your lordship that the statutory intent was to also include the owner within the definition of a lessor.
So let us hear Mr. Mojumdar, Mr. Mukherjee. In the meantime, if you get anything, yes, you can cite that and he'll give a reply to that. Yes, Mr. Mojumdar.
First, the impugned judgment. Number 1, 2, and 4. At page 40 of volume, part 1. Part 1.
Page 40, yes.
Now I will just read the first paragraph.
Right.
Issue number 2 and 4 are taken up for discussion together for reasons of convenience and brevity. The plaintiff, namely Subodh Samanto, filed affidavit in chief in which he corroborated the plaint case and which the affidavit in chief he tendered in court as PW1. PW1 stated in his cross-examination inter alia that the suit property was taken on rent for using the same as godown of WBSEB in 1980 and that an agreement was executed between him and WBSEB on 16/7/1980 and that inter alia Vivekananda oil mill was lessor. So, this is the specific case during the course of cross-examination. The plaintiff admitted that Vivekananda oil mill is the lessor.
Yes.
And WBSEB was the lessee and Vivekananda oil mill was a partnership firm. And inter alia, who were the partners? Shomiran Samanto, Shambhunath Samanto, Shanot Samanto, and the plaintiff were the partners of that firm at the time of execution of the lease agreement. PW1 further stated in his cross-examination inter alia that he became the absolute owner of the suit property in 2009, and that after he became the owner of the suit property, no new lease agreement was executed between himself and the electricity authority. Inter alia, from the evidence of PW1, some documents were marked as Exhibit 1 to Exhibit 8 after objection. So, my lord, the first thing is that, my lord, the Vivekananda Oil Mill was the lessor. WBACB, my lord, that is my predecessor, was the lessee. Secondly, my lord, according to the plaintiff, he became the absolute owner of the property in question by operation of a solenama in 2009. Now, my lord, the first thing I would like to point out is that this judgment decree is not an authority for the proposition or for the fact that whether this plaintiff before the trial court or the petitioner before a lordship, the appellant before a lordship, is the owner of the property. There is no decision to that effect. At least, my lord, I could not find from the judgment. Secondly, my lord, kindly take now the registered deed of conveyance, which is at page 2 or 1 of the, my lord, this part 2. These of 1963, as pointed out by Mr. Mukherjee. Your lordship will find there is a schedule at the end of that, obviously the deed of conveyance, which is at page 2. Well, the dark numbers are there, and the property, the quantum of the property is also laid down. Now, along with that, now kindly now take the lease deed, which is at page 24 of part 2. Part 2. It has been contained on behalf of the petitioner, appellant, that Vivekananda Oil Mill was never the owner. First thing is that Subodh Kumar Samanto, who is the plaintiff or the appellant before a lordship, was also a party to this agreement. Kindly may I just read out the first 2 paragraphs. The recital part. This indenture made on such and such day, referred to as the lessor. Who is referred to as the lessor? Vivekananda Oil Mill. Which expression shall, unless excluded by or repugnant to the context, include its successor or successors and the partner or partners for the time being of the said firm and their respective heirs, executors, administrators, representatives assigned. Emphasis is required to be supplied to the expression for the time being of the said firm. Therefore, my lord, the deed of lease also perceives of a situation, contemplates a situation when there may be a change in the constitution of the partnership.
All right.
So, my lord, this deed does not in any manner confer any right on one partner to, my lord, deal with the property otherwise. Otherwise, my lord, for the time being of the said firm, expression would not have been used. Subject to correction, my lord. This is my humble understanding, my lord. Now, my lord, kindly take the first recital. Same page. My lord, the lessor, obviously, my lord, the lessor would be, my lord, Vivekananda Oil Mill, is seized and possessed of or otherwise well and sufficiently entitled to all these several pieces or parcels of land, the premises of formerly Vivekananda Oil Mill, together with godown structures erected thereon or on part thereof, situated at Bardhaman, Swanso Road, Jagodbera, PO Burdwan, in the district of Burdwan, more particularly described in the schedule hereunder, written and delineated in the map annexed and thereon bounded thereafter for the sake hereinafter for the sake of brevity collectively referred to as the said premises. So my lord, the deed says, my lord, we have my lord, this entire case, even the my lord, the notice for eviction under section 106 has been issued on the basis of this deed only.
Yes.
The deed clearly says that the lessor is seized, possessed, and entitled. So, there should not be any reason, the plaintiff should not be permitted to take a stand that the Vivekananda, we do not know, what happened between 63 and 80. That is not disclosed anywhere. That is not even the subject matter. But what we know as of now, there was a lease deed, and in the lease deed, it has been specifically provided that Vivekananda Oil Mill is the lessor, and the expression used is that otherwise well and sufficiently entitled. And Subodh Kumar Samanto, the plaintiff, was the partner or is the partner of the partnership firm, being the lessor. Now, point number 1 about 2 1. Oh. Now, Miller, kindly take, my lord, now this indenture witnessed, that is at page number 25, in consideration of the rent hereby reserved and of covenants condition and agreements hereinafter contained and the part of the lessee to be paid and observed and performed, the lessor do hereby demise unto the lessee all those several piece and parcels of lands together with godown structures and office room, etc., created thereon or on part thereof and containing by a measurement in aggregate an area of 40,750 square feet, be the same a little more or less situated and lying at Jagatbera, Bardhaman, on Bardhaman Municipal Holding number 19 in the district of Bardhaman, together with electrical wiring, etc., etc. And my lord, kindly mark the rent, which is at page 26. This will be very crucial, my lord. The rent which was fixed at the time when the deed of lease was entered into by and between Vivekananda Oil Mill as the lessor and WBACB as the lessee was 7,536 per month. Then, my lord, kindly take, my lord, clause E.
Yes.
The lessor hereby appoint Shonat Kumar Samantamal, who is a partner, to be their agent in the matter of realizing bills and making correspondences with the lessee, and the lessor shall be bound to confirm all acts and deeds done by the said Shonat Samanto. So, my lord, this is what's the understanding or the agreement entered into by and between the two parties, Vivekananda Oil Mill being the lessor. So, my lord, what we did, the WBACB, now WBACDCL, paid rent to Shonat Kumar Samanto without any default and continued to pay rent even at the enhanced rate. And that would be evident from, my lord, the notice for eviction under section 106. Now, my lord, kindly take the schedule, because I will come to the schedule. The schedule is disputed, my lord. Kindly take the schedule, because, my lord, I will refer to the map appended to the Solenama. The schedule above referred to is at page 29. My lord has got that?
Yes.
This again, my lord, 58 kata, 12 square feet, etc., etc., BSC, little more or less, formed out of land, godown, office accommodation, Jagatbera, Bardhaman, comprised of Dag number 996, Khatia number so and so, RS plot number 996, 753 old, holding, it should have been LR, I suppose. It's a typo, what
yes, yes.
So and so, particularly delineated in the map or so and so. So this is what is given. On the west, kindly mark the last portion, and on the west by Bireshwar Oil Mill. Murders got that? At the end of the schedule,
yes,
on the west by Bireshwar Oil Mill.
Yes.
I will take your lordship to that part later on. Now I take your lordship directly to, my lord, the Solenama. The Solenama, your lordship will find at page 6 of the, my lord, this part 2. But this was a compromise between the parties. What the plaintiff in that case two was Subodh Kumar Samanto and one Lakshmi Narayan Samanto.
Yes.
Who was one of the purchaser, as would be evident from the deed of 63. My lord, Vivekananda Oil Mill as a partnership was not a party to this Solenama.
No.
And Vivekananda Oil Mill as a partnership being, my lord, a body corporate, my lord, any commitment made by Subodh Samanto or any arrangement made entered into by Subodh Samanto with some other party in a different suit cannot bind me. Now, my lord, kindly take, my lord, schedule K, which is at page 8. There's some typo which is acquired, I think, or something like required, I don't know. It refers to, my lord, this 996, current DAG number is 996, it says.
Yes.
Then, my lord, kindly take the map, which is at page 10.
Yes.
My lord, kindly take, my lord, if we take the map, it is very difficult to delineate which part is 996 in this map. Well, at least I cannot.
No.
Well, Mr. Mukherjee can. I'm not in a position to do so.
It should be a colored map, Lord. We have, I think, Lord, we have to check it up.
But
Because,
most
the
interesting
legend is here in the map.
Oh.
Well, most importantly,
The-
what is most important?
Subodh and Lakshmi Narayan, Lord, these are,
Yes.
this must be, Lord, in this portion. এইটাতে থাকে
এইটা কিছু
হ্যাঁ,
একটা
ওই
ছিল
একটা-
কিন্তু সেটা কিন্তু বোঝা যাচ্ছে না
with reference আমি বুঝিয়ে দেখিয়ে দেবো
Now, my lord, kindly take, your lordship has found, your lordship has noted that the property in question, where, my lord, this WBSEDCL or WBSE SEB is a lessee, that property is butted and bounded on the west by Bireshwar Rice Mill. Right?
Oil.
Bireshwar Oil Mill.
Yes.
But here your lordship will not find any reference to Bireshwar Oil Mill. On the west, if we take the property as a whole, on the west, my lord, it is Vivekananda Primary School. On the right, it is Rice Mill, which is not in operation anymore, correct? On the north, on the north, it is Vivekananda College Road, correct? On the south, my lord, open land of others. But, my lord, I cannot find, my lord, if your lordship kindly takes, if this is the basis of their claim, my lord, my lord, it is a subject matter of dispute. But this is from their own map. Now, my lord, having regard to that, now I take your lordship to the notice under section 106, which is at page 16 of part 2. ठीक है accepted part. May I just read the notice? Being authorized and duly instructed by my client, this is very interesting, my lord, Sri Subodh Kumar Samanto, residing at so and so, I am issuing this notice to let you know that my said client is the exclusive owner of the land and godown mentioned in the schedule below. You were inducted as a monthly lessee in respect of the said land and godown mentioned in the schedule below. According to English calendar month, initially monthly lease rent was 7536. So, my lord, this notice acknowledges, my lord, the fact that the deed of lease is a valid document. And the rent which was initially fixed was 7536.
Yes.
Subsequently, monthly lease rent has been enhanced time to time. And, my lord, at the time of institution of the suit, my lord, the defendant was paying a rent of rupees 18,785. To whom, my lord? To the lessor, being Vivekananda Rice Mill. Rice Mill, na?
Oil.
Oil.
All oil.
All oil.
No rice.
No rice, my lord. Not good.
Both Vivekananda and Bireshwar.
So, my lord, this is a fact that I had been paying rent to whom? The lessor, not to Subodh Samanto as one of the partners, but I was paying rent to the lessor, namely Vivekananda Oil Mill. Now, my lord, kindly take this is, and the schedule your lordship will find at page 17. It says on the west, Bireshwar Oil Mill.
Yes, the same schedule as that.
Same schedule.
Not was the schedule, not the map. All right.
Now, my lord, kindly take, and there are two plot numbers, my lord. You lordship
Yes,
will find
995 and 990.
yes, the two plot numbers. Now, my lord, this is very interesting. Now, kindly take a further notice was issued during pendency of the suit, which was marked as an exhibit. This is exhibit 8 at page 20.
Yes.
May I just read out this? Being instructed and empowered by my client, Sri Shubodh Kumar Samanto, son of so-and-so, works residing at so-and-so, who was the proprietor of Vivekananda Oil Mill, completely contrary to the deed of lease. Completely contrary to the stand taken on oath at the time of cross-examination.
All right.
So, my lord, now, this is very interesting that the schedule mentioned premises has been leased to you, out to you at a monthly rent payable according to English calendar. Month by my client, initially the rent was 7536 per month. Subsequently, the monthly lease rent had been enhanced from time to time. And lastly, the monthly lease rental of the schedule.
There's another discrepancy here. They say leased out by my client.
My client. Never.
Which was vague in the previous thing. All right.
And my lord, that one Shanot Kumar Samanto, as authorized signatory of Vivekananda Oil Mill, used to collect the rent.
Which is borne out by the lease deed.
Yes. Via this notice, I am informing that Shanot Kumar Samanto is no more an authorized signatory of Vivekananda Oil Mill. That Mr. Shanot Kumar Samanto has no power to act as authorized signatory of Vivekananda Oil Mill, which was a proprietary concern. And which is no more in existence. It is noteworthy to mention here that my client has initiated a proceeding under section 106 of TP Act before Learned Civil Judge Senior Division Burdwan, thereby praying for your eviction, which has been registered as TS 4 number, so and 41 number, so and so, same is still pending. In view of the fact, I am on behalf of my client informing you that legally you are not entitled to occupy the schedule mentioned premises as lessee, and I'm also informing you that not to pay an amount to Shanot Kumar Samanto. Therefore, I am on behalf of my client requesting you to vacate. This is all happening during the pendency of
I can identify with myself, Mr. Mojumdar. When I commit a FOPA, when I try to manage the mess, then it's more of a mess.
More of a mess.
So that's why this letter should not have been written by Mr. Mukherjee's client. Unfortunately, he was not there.
And this has been marked as exhibit.
It is a post-suit letter.
But it
Yes,
has been
post-suit letter.
but
May
it
not
has been
have
marked
much.
as exhibit. This has been considered marked as
It
exhibit.
should not have been marked as exhibit also. Marked as exhibit by them.
After objection.
Yes. Yes. And you objected also. So complete range has been. They sought to exhibit something against themselves. You objected, and it was.
We relied on this. Well, perhaps
No, it's their
they
document.
relied on this.
Exhibit, numeral number
I'm
exhibit,
sorry.
plaintiff's
I'm
document. Yes, yes.
Now, my lord,
You exhibited only that.
No,
please do.
I'm correct. I'm wrong. Kindly take, my lord, my response, which is
You also have a response to this?
Yes, yes. That is also marked as exhibit 8.
Let us see that.
That is at page 23.
Yes. No stone unturned.
Well, again, my lord, in this letter, further letter of the eviction, same, my lord, same mistakes. Two plots are given.
Yes.
At page 20, 1.
20.
995, 996.
Yes. Same. They
Same.
Continue with that.
Now, my lord, kindly now take, my lord, my letter.
Yes.
Which is dated 1/4/2015, marked as exhibit 8. Sorry. In reference above, it may be stated that land and the premises in question has been taken on lease by Vivekananda Oil Mill for the purpose of Burdwan Zonal Store on 16/7/1980. An agreement has been executed by and between Vivekananda Oil Mill and the then West Bengal State Electricity Board to that effect. Being one of the partners of Vivekananda Oil Mill, you have put your signature in the said agreement as
lesser must
be. And since induction, the said land and premises have been used for the purpose of Burdwan Zonal Store. In terms of the said agreement, the authority has paid rent for the same so long you receive the rent amicably. Sri Sanat Kumar Samant has received the rent for Mrs. Vivekananda Oil Mill against a portion of the premises and land in question. However, you are requested to submit the legal documents. So this is a clear case that I have made it clear that the lessor was Vivekananda Oil Mill.
Subsequent letters, sub judice, during pendency of the suit do not matter much, Mr. Moin.
Even if it doesn't matter, my lord.
They
Well,
take
kindly-
time.
kindly
These
take
are not
the-
pleadings.
Well, kindly take the conduct. The conduct is, well, conduct demonstrates the fact that, my lord, no credence should be given to a solenama to which Vivekananda Oil Mill was not a party.
Solenama was a registered solenama. Otherwise.
It was arising out of a suit, court order.
Oh,
Compromise kind.
compromise.
Partition suit ended in a
Partition.
compromise.
Well, that's a partition suit between Lakshmi and Shubodh.
Yes.
Two owners. Two owners.
Two owners.
But my lord,
63, their ownership deed is also there. Purchase.
their ownership deed is there. But
It's
we
a
do
registered
not know, my lord, 1980, Shubodh Kumar Samanto, my lord, was one of the, well, was a partner, obviously was a partner of Vivekananda Oil Mill. And Vivekananda Oil Mill, in the deed, clearly indicated that I am entitled.
Yes.
But Shubodh, being a signatory, cannot take a stand now that, my lord, Vivekananda Oil Mill did not have the title. But we do not know what happened between 63 and 80. It may be so, my lord, this particular property, my lord, became the corpus of the firm.
What was the page of that lease deed again, Mr.
My lord, lease deed, yes, page
Just miss
24.
20.
Part 220.
Part 224.
Yes.
And well-
Sufficiently entitled
Entitled
to all these several pieces of land.
land. Together with, my lord, structure, go downs, etc.
Everything else is there.
Everything
Yes.
else. Only
So
lordship.
entitled not to give the lease, but entitled to the property.
Yes, entitled to the property.
Well.
ঠিক আছে.
But they keep it vague. The lesser is seized and possessed of or otherwise will
But whenever an
sufficiently
expression-
entitled.
Whenever an expression entitled is used, my lord, it means that, my lord, the party has title to the property.
The devolution of title of Vivekananda is not given, although it might not have been given.
Might not have been given. My lord, the point is that,
But this pitted against their title deeds, Mr.
my
Mujumdar,
lord,
this rules out.
their title deed, my lord, if this rules out, my lord, then their case of determination of lease, etc. rules out, they can file a suit of under section 6. If this case gets ruled out, then this is not a valid document. Then what is this suit about?
No, might have been a valid lease from
My lord,
Vivekananda
if it is
to
a
you.
valid lease,
No, Mr. Mujumdar, that is not our question. Our point is that here this document says that Vivekananda Oil Mill is the owner. Suppose.
right, right.
This document saying Vivekananda Oil Mill is the owner cannot override a valid purchase deed, registered purchase deed in their favor.
Which is 1963.
Prior,
Prior.
yes.
My lord,
So
1980,
they have a title deed,
they
registered
have a
title deed.
title deed registered.
And Vivekananda Oil Mill says, he
My lord,
gives a
it
lease
is-
and
it is
says that I am a.
beyond the knowledge of the tenant or the lessee as to how the title of this property devolved, my lord, was transferred to, my lord, Vivekananda Oil Mill.
There is nothing
But-
on record
but,
to
my
show
lord,
the
as a
Vivekananda.
lessee, we acted on the basis of the representation made by the lessor.
Maybe, but that does not take away their title.
That
Just
may not
because
take
you
away
did
the
not know or
title,
Vivekananda
but
Oil
that
Mill
does not
said.
also clothe them with the power that a lesser possesses.
Yes, that is another argument. I mean, the title is seen from the documents
That is
because the
seen from
suit
the
has been heard out.
It has
I mean,
been
evidence
heard
has
out,
been left.
everything has been done. But, my lord, whatever,
There is no rebuttal to their ownership.
there is no rebuttal to the initial ownership.
Yes, there is not.
1963.
No, initial ownership continues unless you show by rebuttal evidence that that was taken away.
Absolutely, my
There is
lord.
nothing on
But
record.
again, my lord, when they are deciding, my lord, at the stage of partition, whatever they did in the suit, this is a case of kind of compromise decree which they had entered into. My lord, the partnership firm was not a party.
Need not have been. They say we are joint owners by virtue of 63 deed, which is a registered deed, and that is the partition
as
deed is in
per-
consonance.
as-
Solenama is in consonance
Absolutely,
with
my lord,
that.
as fell from my lord.
Yes.
My lord, the right of a sublessor, my lord, sublessee, or the lessor of the sublessor. My lord, sublessor, if the right is, if the sublease first lease.
They
which
should have
I'm-
filed against Vivekananda Oil Mill.
Yes. It's coterminous, as fell from my lord.
All right.
Whatever rights are there, they are coterminous. Or they should have implemented the Shanat Kumar Samanto as a party.
Shanat was just an agent as per the
Matlab,
district.
they say they are in their letter, first letter. Matlab, I'm not talking about the second letter. The first letter, the eviction, first notice, they say that don't pay rent. To whom? To Shanat Kumar Samanto.
He's no longer an authorized signatory.
No longer an authorized. So, my lord, this is in an effect that the lease deed is no longer binding on them, because the lease deed in express terms say that whatever Shanat Kumar Samanto will decide, the parties will abide by all the decisions taken by him.
Mr. Mojumdar, if in a case suit filed for eviction of trespasser, the plaintiff cannot revert back to a landlord-tenant scenario.
No.
But the converse may not always be true. In a suit filed for eviction of tenant, if it comes out that tenancy is not proved, then still they have a better title and there are Supreme Court judgments,
Absolutely,
they can get an eviction against a trespasser also.
My
It's
lord,
a lesser right.
my lord, as fell from your lordship, the expression lesser, which has been specifically defined in the TP Act, my lord, something has to be written into that.
But they have a better title than you.
My lord, I do not have a title. I have a possessory title as a lessee. I do not claim that I have a title. I say that my lesser was Vivekananda Oil Mill. You were one of the partners, or you are still a partner of Vivekananda Oil Mill. You in the deed it says that Vivekananda Oil Mill is otherwise entitled to the properties. It's not restricted to the right to grant lease.
Mr. Mujumdar will continue after recess for a short while. You'll just conclude your arguments, and if you want to cite anything, and Mr. Mukherjee will. Let us continue today. Short matter.
I was just trying to, if I can find any judgment, Lord, in support of in the
And
evening,
secondly, my lord, I'm making it very clear, since my lord BR, my lord, there is no attornment in this case. There is no, I have not atturned to the assignee or the transferee. If I had atturned, the situation would have been different. There is no attornment in this case.
কাগজটা এখানে staple করে দেবেন একটু। Tomorrow or today? Tomorrow.
My lord, then my lord, not tomorrow, my lord. Tomorrow I will be held up any day subject to your lordship's permission. Friday, Monday, whichever.
The continuity will be lost, Mr. Mr. Mukherjee, if you have any judgment, you search out, you use your gadget in the during.
difficulties, Lord, from 2 days another appeal, Lord, before just Ajay Mukherjee. I'll not have much time to.
You are the appellant there.
I'm the appellant. No, I'm the respondent there. But
Who is the appellant? Who is for the appellant?
Mr. Aniruddha Chatterjee, and he is the tenant. He is sleeping out of that.
Oh, then it will not happen. Let us continue with this. Either it will not happen or all Mr. Chatterjee will take some time.
Lord, at least the appeal hearing will start.
Let us keep it tomorrow. Mr. Mujumdar, what is it if you would?
Have a matter before in court number 1 tomorrow. I do not know what will be the position of the matter.
If you can't appear before us, then we'll grant adjournment. Let it be tomorrow.
Let it be kept.
Let it be kept in the list.
Kindly bear in mind, my lord, I may have.
Yes, yes, sure.
I may be held up.
And in the meantime, if I find any
My lord, there
judgment,
will
Lord,
be-
to cite, I'll
Give him
I'll give to Mr. Mukherjee.
hard in part for further hearing tomorrow. Take to staple করে দেবেন।
Grateful.
Yes.
Also, my lord takes up the list, my lord. May I mention our original side matter, my lord, that Khemka plastic matter, my lord.
We are not taking up original side. How can you take up?
This is the last day to file the written notes of argument, my lord. So may I file it?
Yes, yes, that we had directly file it before the original side court officers.
Very well, my lord. In the department, okay.
Yes, yes.
Very well.
In the original side court officers before.
Very well, my lord.
Yes, yes. Yes, so when you are for the petitioner.
Apple.
Apple.
Just one thing, my lord, I don't know, my lord. We have just been served a copy of one of the appeal and the application about half an hour back.
Yes, my lord.
And my lord, another thing, my lord, the order is of my lord some vintage, my lord, 26th November 2024 and 12th December 2024.
What was the urgency, Mr.
The urgency is, my lord,
And sorry, just before Mr. Charity,
Here. before the
one
next
thing, my lord, they had
that is why-
undertaken, my lord, that they will make the payment of the money.
that's where the
And my lord,
problem
it comes up, my lord, on the 13th, 12th December, my lord, they had
Tomorrow.
undertaken that. And it was fixed, my lord,
Yes,
30th January.
that's
They had
where the
paid-
problem is.
No, that's not the problem. That's what
That's
the
my
undertaking
pro-
which you gave.
That's my problem.
26th November, my lord, was also, my lord, an undertaking given that, my lord, they want to comply with the order. So these are things, my lord, which
Yeah,
my lord,
I
we have to consider.
absolutely bow
I'm
down.
sure,
my
my
lord.
lord, well.
That
Then
is
what is
exactly
the
what
pressing
my
urgency,
problem
Mr.
is.
Chatterjee?
Pressing
If you have
urgency,
given
my
an
lord,
undertaking, then
tomorrow, if the matter is taken up and my lord, that undertaking, my lord, is enforced, then I go to jail.
no, but you have to pray for that.
That's
before
I'm saying, my lord, there cannot be any my lord estoppel against law.
no, there is no question of estoppel against the law. The undertaking
why I
was
said
before the court.
2 minutes.
Yes.
But there's a history behind it. Now, what happens is I have my lord, a service contract with Vodafone.
Right.
Now, under that service contract, the principal liability to pay the my lord, the dues of the Provident Fund is on Vodafone. My lord, there is an assessment. The order, my lord, is passed by the authorities. That order, my lord, is challenged, my lord, before this honorable court, accepting it, saying that yes, it has to be paid, because Lordship remembers under the law, Vodafone is to pay, I am to collect and pay it, my lord, to the authorities. I have not to pay, my lord, from my pocket. Now, I say that very well. I file a writ petition saying that yes, this is the assessment, this is the dues which is there. I file a writ petition and say, please give me 36 installments so that I can, in the meantime, take it from Vodafone and pay it. Vodafone was not the only one, my lord. There were other companies as well. Fortunately, my lord, all other companies have put in the money, and the authorities, my lord, have gotten, my lord, that part of the money. There is no problem. The problem starts thereafter. My lord, on April, my lord, 2023, there is an assessment again that, my lord, the amount of money which is to be paid is about 1.5, where, my lord, 1.25 is to be paid by Vodafone. Vodafone, my lord, challenges that before this honorable court and says that they were not liable to pay that money. My lord, I had got nothing to do there, basically. I filed another writ petition saying that very well, look here, I will pay the money. This is where my problem starts. Because I was thinking, my lord, if there is an
So what was your liability in the
my
capacity?
liability was nothing. Even
Then why did you
today,
appear and say that you?
that's exactly what my problem is. That didn't happen. I did that now. Before I could do that, I have come up before the court and said that, look here, I will pay. I have said so, that I will pay. Lord, my saying so was based on the fact that I will take the money from Vodafone and pay. My lord, under the statute, Vodafone has to pay. Have a look at just one document. Just one document. Kindly turns to, my lord, right at the end at page 213.
113 of what?
Stay application, my lord.
What the stay?
I did MAT 42.
MAT 42, my lord. (213) and below the relevant portion is 214. Kindly just allows me to place this before your lordship, because this is law. And Vodafone cannot come out of it. Lord, allows me to read with your lordship, Lord. If your lordship, Lord,
This is an appeal against the learned single judge's order.
yes. Where,
The
Lord,
single-
I've been asked to put in the money.
You undertook to put in the money.
Lord,
How can there be an appeal even?
I undertook on the, I'm
It's
saying,
not even consent, it's your undertaking.
my undertaking is that I will pay the money once Vodafone pays the money.
What?
That's the thing.
And this is with the Section 5 application.
I'll tell you, the X has a liability to pay Y. Z comes up and says that no, I will pay.
So you could argue
And
that
this
before
is-
the learned single judge.
This is the problem is that this order is standing on my face. If it's not
If it was so pressingly urgent, Mr. Chatterjee, you should have preferred the appeal within time at least.
the problem was in the meantime we thought of getting the orders which have frozen my bank accounts to get that relief.
Mr. Chatterjee, let us see. The law will see later, but let us see your undertaking once.
Yes, kindly takes that up.
Perhaps, my lord, if you place
At
this, my lord,
313.
perhaps with the great respect, I generally don't, my lord, contradict Mr. Chatterjee, but it's not correctly, my lord, the facts are not, my lord, exactly correctly, my lord, portrayed. So there's an order of 6th April 2023, my lord, which was passed against him, 6th April 2023.
I bow down. I've
By, my lord,
accepted
the
that.
authorities against him. He files, my lord, 2 writ petitions, my lord, challenging, my lord, those orders.
Yes.
My lord, he comes, my lord, there's an order of 20th September and a 29th September order, by which, my lord, he says, I want to pay in installment. He admits his liability, says he wants to pay in installments. Those orders are also recorded. In 2024, my lord, we get a notice. We were not parties. We said we were not even heard. Where's the question of our liability? He also filed another writ petition in 2024.
You are the Provident Fund.
Suppressing.
He's Vodafone.
I'm Vodafone.
Yeah.
My lord, suppressing the fact that, my lord, the 2023 orders were passed. Suppressing. In the order, it is recorded on the 26th of November 2024 that you have suppressed both these orders where you wanted to pay in installment. Then, my lord, again an opportunity given on 26th November where he undertakes that he's going to pay, my lord, by the December, my lord, of 13th of December, my lord, 2024. Which he did not. Again, he went before the court and said, now I'm giving another undertaking that I will pay by 13th January. And, my lord, the matters, my lord, now there are 2 undertakings, my lord, will kindly consider that. Rather, my lord, 3 undertakings from 2023.
I accepted, and that's my problem.
On the question of, my lord, suppression, my lord,
No,
itself, my lord, this
Mr.
will-
Chatterjee, let us come to internal page 7 of that order.
Yes,
26th November order. Please come to that.
26th November.
The impugned order.
Yes, bro. 319.
The last paragraph, please place it at this juncture.
Yes, bro.
Internal page 7.
Yes,
Running page 14 of your section 5. You can place it before the court.
Upon reading the second writ petition filed by the
No,
contractor.
this is at this juncture. Mr.
At this juncture, very well. Mr. Aniruddha Banerjee, proprietor of the
What's the new?
Yes.
The proprietor himself.
proprietor of the contractor firm present in court today instructed the learned senior counsel appearing for him to pay time for 2 weeks within which he shall unconditionally pay the assessed amount under the said impugned assessment. Yes, I would have shown your lordship this. This is
the order under challenge now.
No, this is one order. There's a second order as well. Because I have to get
that must
out
be
of
considered.
this. I'm trying to get out of this by way of law.
No. No question of entertaining the appeal. This is a consent order.
Gives me 2 minutes time.
No
I'll
appeal
try.
lies, Mr. Chatterjee.
Give me 2 minutes time. I'll try and there is a problem with respect to the advocates. There was a problem.
Whatever. No. The client was present in court instructed.
No, thereafter there was a problem.
Whatever. That's your problem.
If I'm allowed 2 minutes time, I'm
Yes, Mr.
accepting
Chatterjee, please.
this.
Please,
I'm
please.
accepting this.
Yes.
This is a problem. I have done this. I'm not saying, Milord, that I haven't done this.
Yes. See the next order also.
I bow down, Milord. I bow down. Because why? Because I wanted to show my bona fide. It is not my liability.
Bona fide?
Yes, Milord. Because what happens is,
There's no B of bona fide in your.
I'll tell you also why there is. Milord, when there is an assessment for, Milord, payment of Provident Fund, the law says it's the person, Milord, who is the principal employer. He is liable. He is liable. I am in my service contract, Milord. It is that I will take it, I will give him invoices, he will pay the money to me, and I will go and deposit it.
Mr. Chatterjee, it is too late in the day to look into the law because the position has been settled in your matter. You have admitted the liability previously
I have
also.
admitted the liability. I have said that
September
I will
orders?
make payments. Liability I have not annexed.
Make the payment.
That is my Milord. If I could have made the payments, I obviously, Milord, would have made the payment.
There is no scope of entertaining any appeal against this. We'll allow the section 5, we'll dismiss the appeal.
My problem is, I'll tell you, Lordship, why. Milord, I am trying to, Milord, make this submission before your Lordship is that there could not have been any estoppel against law. Even if I admit something, Milord, of somebody else's liability, if it is legally, Milord, is on Vodafone, then, Milord, that Liability would not be cast upon me because I have gone and told the court that, look here, I will pay. Ask it.
That chapter is over, Mr.
Kindly seize the order, my lord, which is under challenge. Kindly have a look at it once.
Which order is under challenge?
Yes.
26 November?
Before the writ court. Before the writ court.
No. We'll see only the order which is before,
Before
us. No.
That's the order.
No. We cannot go into the merits of the writ court's order.
Which
You have unconditionally undertaken to pay the assessed amount. Unconditionally.
That was something, my lord, which I say, my lord, that law doesn't prevent me, my lord, from telling the court that, look here, that I might have said.
You have acceded to the order. Under the impugned order dated April 6, 2023, as referred to above, the contractor was held liable. You are held liable. And in a challenge against that, you have undertaken to pay that amount.
If your lordship wants, I'm not going to read
After
it out.
the attachment was issued, then only you took this stand. No. Sir,
Lord, I'm not going to read it
you're
out.
trying to evade the process of law.
I don't want to evade it. My lord, I'm saying that it is not for me that I'm evasive. Evasion is done by somebody else and I've taken it upon me.
Mr. Chatterjee,
Evasion
page
is
4 of that order, it records, September 20th order records, your learned advocate representing the petitioner submits that the petitioner is not interested to question the order.
That is the problem. And my lord, I have emails to that effect that he has said that he's made a mistake. I have emails there.
Anyway.
My lord, which is annexed before your lordship.
No, Mr. Go before the learned single judge and make this point.
Now, may I pray?
So the undertaking was given before the learned single judge.
It was.
There is nothing wrong in the order to entertain the appeal.
I really don't.
So where is the scope of entertaining an appeal? What is wrong in the order?
Basically on my lord, on equity, nothing beyond that. And
Mr. Chatterjee, appeal lies. You could have gone back before the learned single judge and do this. Appeal court has nothing to do with this.
Second time,
What is the wrong committed in this order that we should interfere?
না সেটা তো ওখানে গিয়ে তারপরে এখানে আসতো, that's not the thing. Lord, I am really, Lord, not on that. Lord, why I filed this appeal was only on the question of law, nothing beyond. If a liability belongs to X, it cannot be put on to Y.
There is nothing wrong in the order at all. No adjudication was made in the order as such. The order relied on previous undertakings given by you, and you had stated that you are not interested in challenging that order. And after that, you have undertaken before the court. You also appeared, Mr. Chatterjee.
That was the last occasion.
Last occasion, you appeared and you undertook on behalf of on the instruction of your client.
I prayed for time. I said, Lord,
Yes.
at point of time, I
Yes.
prayed for time to put in the money. There was no undertaking given. as
Instructed
such.
learned senior counsel appearing for him to pay time for 2 weeks, within which he shall unconditionally pay the assessed amount.
Lord, that is true. Lord, I am not reciting from that.
Mr. Mujumdar was appearing for the Vodafone.
No, Mr. Abhratosh Mujumdar.
Mr. Abhratosh. Very well.
What I was trying to, my lord, say is that even if I give an undertaking, which is
Change of
opposed to
counsel
law,
casts a more serious doubt. Casts a more serious doubt than you imagine.
then I started appearing thereafter. But that was because
No,
of
it's not on you, not personally against you.
No.
But change of counsel indicates that the undertaking he's trying to wriggle out of the undertaking.
He is not. The problem is, my lord, he had a, my lord, very bona fide, my lord, I had a, my lord, a talk with the client. He had a very bona fide, my lord, thing in it.
Mr. Chatterjee, will dismiss your appeal right now. We'll allow the section 5, 7 days delay, and we'll dismiss.
Lord, your lordship only records that my lord's not gone into the merits, sir.
What merits? We are going into the merits of the appeal and saying that no appeal lies because of your conduct.
But no appeal lies very well. Very well.
Can 1 of 2025 is taken up for hearing, full stop upon hearing learned counsel for the parties, comma, we are of the opinion that the minimal delay in preferring the appeal has been sufficiently explained and is accordingly condoned. Full stop, can 1 of 2025 is, comma, hence, comma, allowed, comma, thereby condoning the delay in preferring the appeal. Full stop, next para. The appeal has been preferred against an order dated November 26, 2024. Full stop, we find that in the said order, comma, previous orders dated September 20, 2023 and September 27, 2023 were quoted. Full stop, next para. As per the order impugned herein, comma, the September 20, 2023 order recorded that the petitioner, comma, as represented by his counsel, comma, was not interested to question the impugned order dated April 6, 2023, passed under Section 7, capital A of the Employees Provident Funds and Miscellaneous Provisions Act, 1952, full stop. We also find from the recordings in the order impugned before in the present appeal that orders of attachments were passed against the petitioner for non-payment of the concerned amount. Push up next para. Under such circumstances, comma, on November 26, 2024, comma, the proprietor of the appellant firm, comma, who was present in court, comma, instructed his learned senior counsel to pray for time for 2 weeks, within which he shall unconditionally the bold letter, pay the assessed amount under the impugned assessment order dated April 6, 2023 to the Provident Fund Authority after adjustment of the amount already paid by the contractor to the Provident Fund Authority. Pushed up, the learned single judge went on to record that in view of the said submission, comma, the appropriate authority of the Provident Fund Authority in writing after adjustment of the amount already paid by the contractor shall inform the contractor within 2 days from the said date as to the correct quantum due and payable by the contractor under the said assessment order dated April 6, 2023. Full stop. It was further recorded, comma, in bold letters, comma, that as per the undertaking of the petitioner who was named in the order, comma, in the second writ petition, the amount shall be paid to the appropriate Provident Fund Authority positively on or before December 10, 2024, unconditionally. So, next para. By a subsequent order dated December 12, 2024, comma, it was recorded that the November 26, 2024 order speaks for itself. Pushed up. When the writ petition was taken up on December 12, 2024, comma, learned senior counsel within bracket who had there within bracket there had been a change of counsel in the meantime for the appellant, bracket closed, comma, then appearing for the appellant stroke petitioner who was also present in court, comma, on instruction from his client submitted that the order dated November 26, 2024 shall be carried out and complied with on or before January 13, 2025 positively and without any default. Pushed up, subject to such undertaking, comma, on good faith, comma, the learned single judge extended the period for making such payment. Pushed up, it was, comma, as a rider, comma, recorded that the said order shall not be construed as any modification or alteration of the rest of the order dated November 26, 2024, save and except extension of time frame. Push up next para. In the present appeal, comma, the said orders have been sought to be assailed. Push up, learned senior counsel appearing for the appellant seeks to argue that there cannot be any estoppel against the law. Full stop, next para. However, comma, we are unable to accept such contention of the appellant. Full stop. The appellant, comma, after having unequivocally given undertaking several times over before the learned single judge that he was not interested in assailing the impugned order of assessment, but would unconditionally pay the amount within a limited period, comma, which was further extended from time to time at the behest of the appellant itself, comma, without recording any challenge to the assessment order, comma, the appellant cannot be permitted to resile from such specific undertaking given before the court on the flimsy pretext that there cannot be an estoppel against the law. Push up next para. What we are dealing with is not in respect of estoppel against a law, full stop. The undertaking given before a court of law to obtain the advantage of buying time for the purpose of making payment in terms of an assessment order is not restricted to estoppel, but an attempt to resile from the same tantamounts to contempt of court. Full stop. Next para. The appellant, comma, it is evident, comma, is trying to play with the patience of the court. Full stop. Next para. A larger underlying factor concerned is that the delay in making such payments directly and adversely affects the concerned employees, comma, which is also one of the considerations which ought to be borne in mind while deciding the present appeal. Full stop. Accordingly, comma, there is no scope of interference with the impugned orders. Full stop. The learned single judge was perfectly within his rights and jurisdiction to accept the undertaking of the appellant in good faith and merely permit time to make payments to the appellant. Full stop. Thus, comma, there is absolutely no occasion to interfere in an intra-court appeal with the orders impugned herein. Full stop. Accordingly, MAT 42 of 2025 is dismissed along with CAN 1 of 2025. Mr. Chatterjee, we are not granting you cost, not imposing costs on you. We could have, should have rather, but we are not giving you that liberty either to go before the learned single judge.
The problem is, Mullah, that your lordship is only on the
Absolutely recalcitrant client.
not
Mr. Chatterjee, you don't identify with the client.
41 as well,
much
Mullah.
better, Mullah, that's what he should have been. The order is not on him to pay.
Yes, yes.
The order is on him to pay.
No, no, no.
The order is on him to pay.
No, that's
The
not correct.
The
So there are
entire
two
assessment
appeals.
is on Vodafone to pay. And under the contract, Mullah, he is to pay. Under the law, he is to pay.
Your goodness has been offset by your badness.
But
Mullah, he
no,
manipulated the account. That's why Mullah got imposed on him. No, there are
I
two.
come to court and say, he's saying, I will pay. Correct?
You are
And
just, your
now-
client is just trying to play with the court.
Lord,
4 occasions
with
he
a
asked for
lot of
time
respect-
unconditionally
With a lot of respect,
without.
I tell your lordship, with a lot of respect, I tell your lordship, Lord, this client, if I was in his place, Lord, I would not have come to court. He's come to court and said that yes, this is the thing what it
If
is.
he did not come to court, Mr. Chatterjee, he would be behind the bars.
No, because
Contempt.
it's his liability.
No. April 6th.
The order of
Chatterjee,
assessment is
again we are telling you don't identify with the
on
client.
him.
Not getting to this.
Let us call on
The
him.
order, my lord, is on him.
Mullah, there are two matters. Mullah, appeal. Mullah,
Unfortunately,
both from
Lord, I was unable to show your
the
lordship the law.
26th and 11th. Mullah, both were preferred in appeal.
2 appeals.
Two
There are
appeals.
two.
There are 2 Section 5 applications.
sections.
Can one, both?
There is no stay.
There is no stay in the other, my lord, there's just one.
আচ্ছা this order অন্য অ্যাপিলটা যেটা আছে এটা কোনটা করলাম
2 নম্বর আছে 42
ভুল করেছিস এখন আমরা
what was the mat in which the section 5 was the stay was filed
41
41 এ যেটা অর্ডারটা পাস করলাম next para in view of the issues involved being identical comma the order passed in mat 41
40 my lord, the stay in 42 and the other one
তাহলে
is
আগেরটা 42 হলো
হ্যাঁ।
পরেরটা হবে mat 41 এ in view of the issues being identical comma the this appeal and the connected application shall abide by the order passed in mat 42 of 2025
I'm grateful.
হ্যাঁ এটা দুটোতেই যাবে দুটো একসঙ্গে দেখে করবে একটা কমন অর্ডার করে দেবে হ্যাঁ কম্বাইন করে দেবে হ্যাঁ কম্বাইন করে প্রথমে ওটার পুরো অর্ডারটা হয়ে যাওয়ার পর তারপর এটাতে এটা দেবে সেকেন্ড এটা আর ওটা প্রথমেরটা
Or I'm for the appellant in this matter.
ইয়েস মিস্টার কি ভুলেছে
I'm for the respondent.
হ্যাঁ কেন আসেনি কেন কি কেন আসেনি
Out of order rule 27 for our own document.
কেন was filed for this court আসেনি কেন ফাইল আছে তো লিস্টে দেননি কেন কি মাথা নিচু করে দাঁড়িয়ে আছেন বোকার মতো
My lord, this appeal arises out of
Yes.
a decree passed in a suit. It is a degree of dismissal. Passed in a suit filed by the plaintiff for recovery of money for goods sold and delivered. Now, my lord, before this suit, there was some antecedent. That is, my lord, the plaintiff filed an application for winding up in this honorable court against the defendants. And that ultimately that winding up application was disposed of by directing the plaintiff to deposit some amount. I'll be referring to that order.
No, this company was the plaintiff
company,
appellant was a company in liquidation.
Yes, but that application was disposed of by relegating the matter to suit. Well, I'll be placing that. And thereafter the suit was...
There was no liquidation. No liquidation happened.
No.
There was no winding up.
No winding.
Very good.
No winding up. Only the matter was relegated to suit.
Suit for the money claim.
For the money.
Right.
Now, my lord, that is the, my lord, initial stage of the particular dispute between the parties. Thereafter, a suit was taken up. Now, my lord, this evidence are taken and there are several proceedings in the trial court and also in this honorable court in revisional applications in between. Then, my lord, ultimately the suit was dismissed on the ground that the plaintiff firm is not a registered firm in view of section 69(2) of the Partnership Act. Now, my lord, before going into the matters, I'm just giving your lordship and just a glimpse of the matter that that was the ground for dismissal of the suit, and all the issues are taken up and discussed, but ultimately conclusion was that the suit, since the suit is not maintainable, so that decision was not taken. Now, my lord, paper was filed showing that the partnership firm is registered. That was marked exhibit, but that was not relied upon. Now, my lord, thereafter...
Not relied upon by you or the court?
By the court.
Why? On what ground?
My lord, I will be placing that. Now, my lord, in continuation of that document, that was the certificate given by the Register of Firms. Now, my lord, what is there in the records of the Register of Firms? We have taken a certified copy, and that we have filed under Order 40 and Rule 27. That is in furtherance of the certificate. And that particular registration matter is touching the very root of the dispute between the parties.
So does the extension of that previous certificate help you if the main certificate is disbelieved? Now another document has been issued.
That is
so you have to satisfy us on merits also. Yes.
That is the question to be decided by your lordship.
Yes, absolutely.
That is the question to be decided.
Absolutely. If you disbelieve the main certificate, then something given in pursuance of that may not help.
Exactly so. Exactly so.
But till date, the registrar is is relying on that certificate that you are trying.
Oh, sure. Relying upon this. Yes. By the certificate by Register of Firms. Now, my lord, as I understand, my lord, subject to your lordship's kind desire, my lord, that the main dispute is with regard to the registration of the firm. If we go to the, my learned friend also agree that if we go to the discussions made by the learned trial court with regard to the different issues, well, issues are discussed and ultimately said, since the suit is not maintainable, I am not going further.
Issues are held in a favor otherwise?
Yes. Several issues in my favor. No. Ultimate decision was not given, but discussion.
No. The issues were not held in.
That was not so. But they are half done, my lord. Because of the not maintainable point. No, my lord, I think, my lord, that is whether that particular document is which was marked exhibit and which was given by the Register of Firms. What is legal value? That is the main crux of the matter. And if that legal value stands in my
So
favor,
even if you win this appeal on that point, Mr. De, our intention was to ask you that we have to remand it to the trial court to decide on the merits. But otherwise, if those were held in your favor, then if you reverse that, then
I apprehended that, my lord. That may be your lordship's, my
no,
lord.
if all the issues were otherwise, this is all subject to hearing, Mr. Mukherjee. We are just posing a question to you, or whether we can suppose we reverse this issue. If you win on this issue, then the other issues have already been held in your favor, so that we can pass a decree from here.
My lord, under order 41, rule 31, your lordship knows, my lord. And there are several judgments on this point by the Honorable Supreme Court. I've got one with me. That if the evidence, entire
Is
evidence
sufficient,
is on record,
we can.
then my lord, your lordship is ample power to
So
decide the
what
matter.
we meant is that the trial court did not finally hold in your favor the other issues also.
Oh, no.
It is not a case
Before
where
coming to the conclusion, he learned trial
discussed, but no conclusion on that.
No conclusion.
Very well.
Now, my lord, what I am submitting, my lord, your lordship kindly take up the part 2 and let us see the order passed by the Honorable Court in the company matter. That was the judgment passed by my Lord Justice Sanjeev Banerjee, as your lordship then was. Exhibit 2, my lord, part 2, my lord, at page 179.
Yes. Yes.
Now, my lord, the claim of the petitioning creditor is on account of price of goods sold and delivered. The petitioner claims that between January 2006 and March 2007, several lots of supplies were affected by the petitioner to the company, and 12 bills in respect of such supplies remains outstanding. The company's defense is that no goods were received by the company in respect of these bills, that the petitioner has colluded with one Taragnath Mitro, a former director of the company, to raise fictitious bills and so fabricated acknowledgement of the bills in the company's records. And there is a bona fide dispute that the company raised prior to the issuance of the statutory
No, this
notice.
company is the defendant company.
My lord.
You are the petitioning creditor.
Yes.
You sought for liquidation, winding up of the defendant company.
Now, my lord, the petitioner has appended copies of the bills and the related delivery receipts. The first demand for payment of 12 bills along with other appears to have been made by the petitioner by letter of June 3 to 2008. The company took its time to respond to such letter, and on August 1, 2008, issued its reply alleging that a substantial part of the claim made by the petitioner was apparently at the behest and with connivance with the erstwhile associates of our company. The company, however, acknowledged that 2 of the bills that had been referred to in the petitioner's demand of June 3, 2008 were genuine, and the company enclosed a check for rupees 1,26,609 in respect of the bills and accepted as genuine by the company. The statutory notice was issued on January 16, 2009. The statutory notice must have taken at least a couple of days to travel to the company. The petition was affirmed on February 7, 2009 and filed on February 10, 2009. The company says that the petitioner did not allow the company sufficient time to respond to the notice, since the petition had apparently been affirmed prior to the expiry of 21 days from the date of submission of statutory notice. The company has appended a copy of its reply of February 7, 2010 to its affidavit. In such reply, which was obviously been issued without notice of the petition having been filed, the company elaborated on its earlier assertion that an erstwhile director of the company had colluded with the petitioner to set up a fictitious claim. The company denied receipt of any 12 bills for which a claim had been made by the petitioner in the statutory notice. In addition, as against a payment shown to have been received by the petitioner in his statutory notice, the company explained its reply of February 7, 2009 that such payment of 1,26,609 was against a discrete amount covered by 2 several bills dated July 5 and July 6, 2007. At paragraph 4 of the affidavit and various subparagraphs thereunder, the company has explained the stand. The company says that Tarugnath Mitra had apparently colluded with a number of suppliers such that if the suppliers had raised a few genuine bills, Mitra would include a few other fabricated bills together with the genuine bills and foist a fictitious liability on the company. The affidavit speaks of Mitra having resigned as a director of the company on July 19, 2007, and having severed all relationship with the company. The affidavit does not allude to any steps taken by company against Mitra for his alleged illegal acts and conduct. The affidavit does not otherwise demonstrate or even name other suppliers with whom Mitra have conspired and acknowledged fictitious liabilities on behalf of the company. The company does not otherwise indicate any nexus between the petitioner here and Mitra that would lend credence to the company's charge that fabricated bills had been introduced in the records of the company or the complicity of the petitioner in the illegality sought to be perpetrated on the company by Mitra. In course of the proceedings, the petitioner sought to leave to issue subpoena to commercial tax authorities for the records and documents filed by company to be produced. Certain records are produced in the court, and copies of these records form part of the supplementary affidavit filed with leave of the petitioner. The petitioner seeks to demonstrate inter alia from page 93 at pages 210 to 214 of the supplementary affidavit that not only had the bills been referred to the documents lodged in the statutory authorities, but where the bills or the documents covered thereby did not tally, it was the matter of simple arithmetic to ascertain that company had represented to the statutory authorities as to the authenticity of the transactions covered by 12 bills referred to in the petitioner's statutory notice. Before the merits of the matter were taken up, the company offered to secure the claim of the petitioner to the extent of rupees 12.38 lakh without prejudice to its rights and contentions. But at a later stage, company has sought to justify its offer to secure 12.38 lakhs on the ground that such amount reflected some of the amounts covered by the bills, which can be ascertained from the documents relied upon in the supplementary affidavit. The company says that it would involve substantial guesswork to glean out the figures and relating to the other bills. The company implies that such exercise in summary jurisdiction is fraught with danger. The petitioner says that in addition to the stand taken by the company in its response to the statutory notice, the company has relied on a certificate by a central exercise and service tax consultant, which appears as Annexure E to the company's affidavit. The petitioner says that the consultant is but an employee of the company, and notwithstanding such charge made in petitioner's affidavit in reply, since the company has chosen not to file its rejoinder to the supplementary affidavit within time, such assertion remains uncontroverted. The petitioner also asserts that contrary to the contents of the certificate, there is no provision for reversing the benefits obtained by in respect of the CENVAT. CENVAT is central VAT. The petitioner refers to the certificate as page 29 of the company's affidavit and compares the bills, numbers, and particulars therein with the entries at page 93 of the supplementary affidavit at page 210 to 214. The petitioner is able to show that the bills being TC 44, TC 45, and TC 123 covered by the first bunch of the bills in certificate issued by the consultant, and bill numbers TC 01, TC 15, TC 28, TC 66 covered by the second bunch of the bills referred to in certificate appears from the particulars of the purchase register, and that has been furnished on behalf of the company to the statutory authorities. Pages 210 to 214 of the supplementary affidavit form part of the contents of the company's purchase register for the financial year 2006-7 that have been verified and submitted by Subroto Dotto, director of the company, who has affirmed the affidavit on behalf of the company. The other 5 bills referred to in the certificate of the consultant appearing at page 29 of the company's affidavit, according to the petitioner, are reflected in the particulars at page 93 of the supplementary affidavit. The petitioner claims that at least 3 columns at page 93 of the supplementary affidavit reflect the gross amount, net amount, less VAT, and VAT amount respectively in respect of the bills. The petitioner refers to bunch of entries relating to trade center. Trade center is the plaintiff. The proprietorship concern of the petitioner that appears towards the middle of page 93 of the supplementary affidavit. The petitioner says that it is apparent from the 5th column that last column of the page that if the VAT amount is indicated in the 5th column, the entries in the 3rd and 4th column in respect of the trade center transactions are obviously erroneous. By way of example, the petitioner takes one of the entries in the 5th column where the amount of VAT is reflected at 2373. The petitioner says 2373 is the VAT amount. Then the amount of the bill would not be as is reflected in the corresponding entry relating to the same transaction in the 4th column. The petitioner says that if the entry in the 4th column is read to be as reflected in the relevant bill, it would appear that an amount of 4% thereon would be 2373.72. The petitioner says that it is amount of 2372.72 that had been rounded to of rupees 2373. The petitioner says that if rupees 2372.72 is taken as the base figure and the total amount of the bill attempted to be ascertained therefrom, it would appear that the entries in the 3rd and 4th column of page 93 of the relevant bills are utterly erroneous and the correct amount would tally with the relevant bills raised by the petitioner on the company. There appears to be substantial basis to the petitioner's claim in respect of almost every entry relating to the trade center appearing at page 93. In any event, the company has accepted that at least 2 of the bills relating to TC 152 and TC 160 are relatable to the bills which figure is in the petitioner's statutory notice. In fact, the company seeks to justify its offer of securing 12.38 lakh on the basis of amount covered inter alia by bills TC 152 and TC 160. The petitioner has referred to the judgments reported at 1990 volume 1 CLT 265, 129 ITR 426 and 2009 volume 1 CH1 1073. There is no revolutionary principle of law enunciated in any of the
Typical of Justice Banerjee. No revolutionary principle. I can visualize Justice Banerjee saying.
Yes.
You have been sitting with him.
Yes. Sitting with him, arguing in his court for a long time.
Yes.
And we had a very, very valuable judgment now was in question in the Honorable Supreme Court in Rajesh Mitra's case by your lordship sitting with Justice Banerjee. Now, my lord, there is no revolutionary principle of law enunciated in any of the judgments. These judgments speak of a creditor's winding up petition being registered only upon a bona fide dispute being set up by the company. In particular, the petitioner has relied on the judgments reported in 129 ITR 426 for the proposition that internal disputes within a company would not affect the claim of the creditors of the company. In fact, in that case, the dues of the company to the petitioners are reflected for successive years in the balance sheets and annual accounts of the company, and the company raised a dispute by questioning the admission and acknowledgement that appeared in the balance sheets. The company says that it would be evident from the pre-statutory notice dispute and the same being ultimately reflected in the final stand taken by the company that it has invented no additional dispute but has stuck to the original dispute indicated on August 1, 2008. The company submits that it has made an offer to secure a part of the claim to show its bona fides. The company asserts that the genuine disputes have been raised, and notwithstanding some of the bills are reflected in the documents filed in the statutory authorities, the petitioner is required to demonstrate that the goods were indeed supplied. The company says that the petitioner has made no attempt in such regard. The issue in the present case is not as to whether the company should be afforded a chance to pay the entire amount claimed to ward off admissions of the petition. Since there appears to be a pre-statutory notice dispute which was raised on the first demand by the petitioner, the defense does not appear to have been afterthought for it to be completely disregarded or be described as sham or moonshine. There was a dispute raised at the earlier stage. The petitioner has been able to demonstrate that notwithstanding such dispute, the records filed in the statutory with the statutory authorities would reveal that the bills which had been sought to be disowned by the company form part of the company's records. However, the fact that the bills formed part of the company's record would not run contrary to the case made out by the company that one of the erstwhile officers had sought to foist a fictitious liability on the company. In fact, the very fact that Subroto Datta signed the purchase register of for the year 2006 and 2007 prior to Taraknath Mitro's severance in connection with the company, it would demonstrate that up to the end of the financial year 2006-7, the company and Subroto had no reason to suspect any complicity of Taraknath Mitro with the suppliers or Mitro surreptitiously including fictitious bills in the records of the company. This is very important. Then, my lord, the claim of the petitioner had been substantiated in more protracted proceeding. The claim of the petitioner has to be substantiated in a more protracted proceeding than is conveniently possible in the summary jurisdiction. Since the company had at the outset offered to secure the claim of the petitioner to the extent of rupees 12.38 lakhs, and since to glean out the additional amount claimed from the details appearing in page 93 of the supplementary affidavit would entail the some elements of imagination, the company's offer is accepted to be bona fide. The claim of the petitioner is relegated to suit. Well, here we are getting that. Suit subject to companies depositing security cash in favor of registered original site for the sum of 12.38 lakh. Such security need to be furnished within a period of 3 weeks from date. Upon security being furnished as directed, CP number 57 of 2009 will remain permanently stayed. In default of the security being furnished within the period, the petition shall stand admitted for the sum of rupees 12.38 lakh with interest of 8% per annum for the date of statutory notice, and the petitioner will advertise the petition once in statement and once in Dainik Pratidin. The advertisements would indicate that the matter will appear in court for the first available working day after expiry period of 4 weeks from the date of publication. The publication in the official gazette will stand dispensed with. The balance claim of the petitioner will at any event stand relegated to suit. In the event the security is furnished within the time permitted, the registered original site will cause a deposit of the amount to be made with the nationalized bank having its office within the vicinity of this court and make over copies of the fixed deposit receipts to both sets of parties. The further fate of the deposit will be avoided by the result of the suit that the petitioner may bring or the orders that may be made therein. If no suit is filed within 3 months from the date of petitioner being intimated of the security having been furnished, the company may apply for refund of the deposit, and the petitioner will be able to liable for registrar's commission and the cost to be assessed. There will be no order as to cost.
So this amount of 12.3 it was deposited.
It is deposited. It is
With
lying.
8%. Yes.
It is lying with the register. And so, before going to the, I like to place the judgment there after this. Thereafter, I will go to other points. Then, our idea will be somewhat clear.
Absolutely.
What is the matter?
Yes.
Now, here from this company petition, from the observation made by the Honorable Judge of this Honorable Court, it appears that a dispute, bona fide dispute, was sought to be raised with regard to a particular director, Taraknath Mitro, who has made all these mischiefs.
Yes.
In manufacturing all these bills, etc., and also entries, etc.
Some of the bills, because the allegation is that taking advantage that there were some transactions, he manufactured other bills also.
Other bills also. It is his habit doing so with other companies, etc., etc. And we are also getting that nothing was produced, that any action was taken against Taraknath Mitro or any other companies involved in this in the conspiracy. Then nothing was here. Then, my lord, that is the whole question to be, my lord, decided in the suit. Otherwise, my lord, we are getting
No, independently, you also have to prove that the work was done by you and that you are entitled to the other quantum of bills.
Yes, yes, that is
because it's your suit ultimately.
Now, Dr. Potter. Now, my lord, here, my lord, the copies of the returns filed by the, my lord, taxation authorities are produced before this honorable court, and the copies thereof were supplied to both the parties. This was the, my lord, so far as the company petition is concerned. Now, my lord, kindly see, let us see the judgment at page part 1, my lord, at page 121. Now, starting from page 122, with judgment with reasons. It is a suit for realization of money. The factual matter of the case of the plaintiff, bereft of unnecessary details, is to the effect that it is a reputed partnership firm engaged in inter alia in the business of iron merchants, commission agents, and general order suppliers. Plaintiff mentioned that the original claim was against a company, namely Exomate and Allied Products Private Limited, and hereafter referred to as the transferor company, but the said company got amalgamated with the instant dependent company as per order dated June 26, 2009, passed by the Honorable High Court at Calcutta. According to the plaintiff, the scheme of the amalgamation provided for transfer of liabilities of the transferor company of the defendant company. The plaintiff mentioned that in course of business transactions, the transferor company had placed various purchase orders diverse days between March 2006 to July 2007 upon the plaintiff for supply of MS angles, MS channels, and MS flats, RS joists on diverse lengths and sizes and specifications as per purchase orders. According to the plaintiff, in accordance with the said purchase orders, duly sold, supplied, and delivered the goods, and the same were received by the transferor company by signing the challenge with the transferor company seal without any objection and or grievance as to the quality and or quantity at any point of time. Further, as per the plaintiff, all the supplies so made by the plaintiff are received by the transferor company without raising any objection earlier. Then, thereafter, as per the plaintiff, pursuant to the suppliers made the transferor company, various bills were raised upon the company to the tune of rupees 21 lakhs. 21 lakhs.
Yes, 21 lakh 2000. No, comma in the wrong place. So whatever this amount.
Anyway, that amount and the said bills were received by the transferor company without any objection. Plaintiff then mentioned that the transferor company for the first time.
So the last 7 may be wrong. I mean that may be the oblique.
Yes, 7 should not be
7 is the oblique, the stroke. Yes, yes. No, not so much.
You'll also correct me. Yes.
Yes, sir.
Then, my lord, the plaintiff then mentioned that the transferor company for the first time by its letter dated 1st of August 2008 denied and disputed the bona fide claim of the plaintiff. Along with the said letter, the transferor company forwarded a check of rupees 1,26,609 on account of the bills raised by the plaintiff, being bill number 32 by 0708 and 33 by 0708 according to the company. Apart from the said bills, no other bills due and payable by the transferor company to the plaintiff. The plaintiff mentioned that it had accepted the payment of rupees 1,27,609 made by the transferor company without any prejudice to the rights and contention as part payment of the total dues which was outstanding and due to the plaintiff.
So this got reduced from the main claim.
Well,
this was paid to you.
Yes, yes.
Out of 21 lakh 2000 something, this was paid to
The
you.
company petition also.
All. Yes.
Same fact.
Right.
According to the plaintiff, From the time to time, demands for payment of the said sum of money were made, but the transferor company failed and neglected to liquidate the entire dues to the plaintiff, and hence the plaintiff had filed the winding up of the transferor company by the company petition number 57 of 2009 before the Honorable Calcutta High Court, where the Honorable High Court by the order dated 13 April 2010 directed the transferor company to secure the claim of the plaintiff to the tune of 12,38,000 by depositing same with the London Register Original Site, Calcutta. It was further directed in such order that if the entire claim of the petition plaintiff is relegated to a suit, then the amounts so secured will stand to the credit of the suit. It was further case of the plaintiff that the goods sold, supplied, and delivered or received by the transferor company without any objection and or grievance as to the quality and or quantity at any point of time, and those were consumed for his business purpose. The plaintiff claimed that from the purchase statement of the transferor company and record submitted before the commercial tax department by the said company, it will be evident that the goods were actually received by the company and the said company had taken the tax benefits thereof. But for pausing here for a moment, tax benefit means, my lord, for our clarification, my lord, whenever something is sold, then tax is realized, VAT is realized, my lord. Then after the taking delivery of the goods, the finished products are done. Thereafter, then when it is sold, my lord, then the adjustment of the tax paid at the time of purchase is taken for the dues at the time of selling. That is the procedure for VAT. So tax benefit thereof has been taken. It is the case of the plaintiff. Now, plaintiff thereafter averred that the transferor company got amalgamated with the instant defendant company as per order dated June 26, 2009, passed by the Honorable High Court at Calcutta. As per the plaintiff, the cause of action of the suit arose on 2nd of September 2008 after the demand notice was made by the plaintiff when the part payment was done by the transferor company, hence the suit. The plaintiff has now prayed for a decree of rupees 24,36,105 as described in paragraph 13 of the plaint and its schedule, along with interest and other reliefs. Now, after the suit was filed, the defendant appeared and filed a written statement where it mentioned that the suit is not maintainable and the same is barred by the law of limitation. Inter alia, defendant mentioned that the plaintiff was a supplier of MS plate, etc., to Exhumate and Allied Products Private Limited, which has merged and or amalgamated with the defendant pursuant to the order of the Honorable High Court at Calcutta, sanctioning a scheme of arrangement under the provisions of the Companies Act 1956. It is admitted fact that there is amalgamation. The defendant mentioned that according to the references to the defendant in this suit mean and this include the Exhumate and Allied Products Private Limited prior to such merger as the subject matter of the present suit related to that period. The defendant averted that the supplies are made by the plaintiff against order placed by the defendant from time to time and at all material times. The plaintiff was well aware that Subroto Dotto used to look after, supervise the execution of manufacturing activities, works relating to, while Taragnath Mitra, who was the then director of the defendant, used to look after and supervise all accounts, finance and purchase of the defendant, including sanctioning of bills and supplies, with the authority to singly sign the checks on behalf of the defendant. These are very material assertions. Now, the defendant further mentioned that it came to the light that the said Taragnath Mitra, in collusion with the collusion and conspiracy with the certain suppliers, was siphoning away the funds of the defendant by making payment to fictitious and fabricated bills purportedly raised on the basis of fictitious and fabricated challans of such suppliers, showing purported delivery of purported materials without such materials actually being either ordered by or delivered to the defendant. The defendant claimed that such siphoned money was evidently being shared by Taragnath Mitra and with concerned suppliers. This is very important. This is very important. This allegation. It is also claimed that forged and fabricated documents are being manufactured by said Taragnath Mitra in collusion and conspiracy with all such suppliers relating to such fictitious bills, and that the said Taragnath Mitra would sanction and make payment to such suppliers for both genuine bills as also the fictitious and fabricated bills. The defendant averred that such checks were signed only by the said Taragnath Mitra, and neither the defendant nor other directors were aware of such siphoning of the funds. The defendant mentioned that in June 2008, the plaintiff by his letter dated 3rd June 2008 demanded payment of rupees 24,36,105 in respect of several bills and challans purportedly issued during the period from March 2005 to July 2007. As per the defendant, out of the same, only one bill was genuine and payable in respect of in respect of which supplies had been made to and received by the defendant. The defendant mentioned that in collusion and conspiracy with each other, the said Taragnath Mitra and plaintiff have brought into existence the said fabricated bills and the challans and or other documents in respect of the same, and wrongful and illegal demands have been made on the basis of the same. The defendant then claimed that subsequently it transpired that in an attempt to give color of genuineness to the fictitious and fabricated bills, the said Taragnath Mitra, in collusion and conspiracy with some suppliers, including plaintiff, had included some of the said fabricated bills with genuine bills, and the same at the time of obtaining the same VAT credit, and neither the defendant nor Subrata Datta was aware that at the time of same VAT credit may have been obtained by the said Taragnath Mitra in respect of some of the fictitious fabricated bills to suit his personal ulterior motives. According to the defendant, after coming to know of the same, the defendant has refunded, paid, and or reversed to the excise department, along with interest, any credit that may have been obtained by said Taragnath Mitra in respect of any of the fictitious fabricated bills. This line is very important, very, very important. Accordingly, as per the defendant, has not received any benefit of senbat in respect of the fabricated bills which are at the subject matter of the present suit, The defendant thereafter contended that the plaintiff has been acting in collusion with the said Taragnath Mitra to defraud the defendant and cause loss to the same. According to the defendant, the plaintiff had supplied goods to the defendant, and the defendant duly made payment of all supplies made by the plaintiff, and that no amount is due or payable by the defendant to the plaintiff. The defendant thereafter denied all materials allegations brought against it by plaintiff and prayed for dismissal of the suit. Thereafter, in order to identify the areas of disputes involved in the suit, my learned petitioner in chair has framed the following issues. What issues are framed? Several issues. There are 5 issues. Then, my lord, I'm not reading the issues, my lord, going further, my lord. In order to substantiate their respective cases, the plaintiff had adduced the evidence of one Manoj Kumar Jaiswal as PW1, Ajay Kumar Jaiswal as PW2. On the other hand, Subrata Datta, vice chairman of the defendant company, deposed in the suit as DW1, and Taragnath Mitra deposed as DW2 during the evidence of the above named witnesses.
Taragnath deposed as DW2?
I'm coming to that. It is very interesting case, my lord. It is very interesting case. I think, my lord,
Taragnath came and said that I have committed.
From the conducting of the case by the defendant, my lord, I have learned something. And I think, my lord, those will reflect some light in your lordship's knowledge also. Oh, my lord.
We learn every day.
I know your lordship from your lordship very day one.
Obviously, we have learned from all of you. I have learned from all of you.
Please don't mind me not if I say
you say whatever you like, both of you. I have learned so much from all of you.
My lord. Now, my lord. Then, my lord, the details of the bills are given here. List of the exhibits are there. My lord, very important. Exhibits are there. Exhibits, my lord, trade license was given, certified copy of the order of the Honorable High Court, copy of notice produced, etc., 14 bills, challans, demand notice, original notice for produced documents, 17 number of Xerox copies of documents being page number 16 to 33. These are the documents filed before the company court. Copies are served by the department. These are the copies. Then, my lord, memorandum of registration of 10 dated. This is the whole Exhibit 8. Is the crux of the matter regarding registration. That Exhibit 8. Memorandum of registration number 10576 dated at such and such, issued by the Registrar of Firms, West Bengal. Now, my lord, from the dependent side, these are the documents filed, authorization letter, letter dated such and such, and certificate issued by exercise consultant dependent company, certificate issued by exercise consultant dependent company. This is not the authority, my lord. They are consultant, they are person. Original certificate copies of affidavit of witness along with deposition of money suit number 42 of 2011. There was another suit. Evidence of those suits are taken here. 42.
That is between the same parties?
Not the same parties. Defendant is the same.
Defendant is the
same. Dependent same. Plaintiffs are different. Now, my lord, here, in our suit is number 43.
Yes. Oh. Previous and next.
Previous, yes. And original certificate copies, affidavit of evidence, along with deposition of money suit number 44. Other two suits. Defendants are same, plaintiffs are different. Now, my lord, there are the arguments. If your lordship kindly permit me, so many judgments, so many arguments, my lord, let us go to the findings straightway. That will reduce our time, my lord.
Yes.
So many judgments, so many arguments.
It is ultimately how it was dealt with by the court that matters for the appeal.
My lord, the point raised only the maintainability of the suit. All the judgments are referred to with regard to section 69(2) of the Partnership Act.
Yes.
And my lord, I am not going to dispute with the judgments. If my lord 69(2) is applicable to me, then my lord, there is no way. My lord, the suit has got to be dismissed. I cannot say that. But my lord, I tried to argue there that this is a transaction which is being governed by the Sale of Goods Act. I'll be pressing that, my lord, which is governed by the Sale of Goods Act. And your lordship knows very well, lord, from section 76 to most probably 130, lord, from the Contempt Act has been taken out.
Yes.
And Sale of Goods Act has been formed.
But how does that help you?
Well, their definitions are. I'll come into that. I'll press that. Then, my lord, judgments are there. These are the judgments. So, my lord, if 69(2) applies to me, then, my lord, no question of going to the judgments. My lord. Absolutely clear. Okay. Now, my lord, moreover, we have given the document that we are registered from. That is Exhibit 8, and one document, my lord, I have filed in this honorable court by your Order 41 Rule 27. I want to have it considered by your lordships.
Right.
Now, my lord, and it is the time, my lord, that application has got to be considered at the time of hearing. This is the principle of law laid down so far. Now, my lord, kindly come to page 143. 143. Where do you?
Yes.
Now, my lord, both these issues are taken up together for consideration and adjudication, since the issues are of wide amplitude and embrace within their ambit so many things, which regulate the maintainability of the suit depending on the facts and circumstances of the case. The first aspect that needs to be considered is whether the suit can be adjudicated by this court or not. According to Section 9 of the Code of Civil Procedure, court should try all suits unless and until specifically barred. It is the key proposition of our legal jurisprudence. Presumption should not be held in favor of maintainability, and bar of suit should not be readily inferred. In this suit, the defendant are alleged that the purported claim of the plaintiff is barred by the law of limitation, since the related bills pertain to year 2006 to 2007, whereas suit has been filed in the year 2010. However, if we go to the materials on record, that the pleadings, we would find that the part payment had been done by the defendant on September 2008, and this fact had been admitted by the defendant in his written statement and the plaintiff as well. The defendant has also raised the question of maintainability of the suit. As per London advocate for the defendant, the instant suit is barred by the provisions of 69(2) of the Partnership Act, and it is not maintainable. The learned counsel for the plaintiff contended otherwise, that we have to refer to provisions of 69(2) of the Partnership Act of 1932 in this regard and see whether the instant suit is barred by such provisions or not. In order to slay on the controversy of the maintainability of the suit, which has been filed by the unregistered partnership firm, the court has to consider the import of 69 of the Partnership Act. As such, for a proper appreciation of the dispute involved, it would be appropriate to set out section 69. No, section 69 was set out. Then at the bottom, the provisions of subsection 1 and 2 shall apply to also then a claim of set-off, to a claim of set-off or other proceeding to enforce a right arising from a contract, but shall not affect. These are the provisions, my lord, A, B, C, D. These are the, from the perusal, from the middle, from the perusal of the said section, it is clear that it deals with the effect of non-registration of the partnership firm. Even though under the provisions of Indian Partnership Act, a registration of a firm is not compulsory or does not impose any penalties for non-registration like ones which are imposed under the English law, but the effect of the section is practically such as to make registration of a firm a necessary requirement in most of the cases. It is well settled that the prohibition contained in section 69 is mandatory in nature, and the courts have virtually no discretion in the matter. A proper perusal of the various subsections of 69 makes it clear, and that subsection 1 deals with suit by or on behalf of any person, suit as a partner in a firm against the firm or any person alleged to be or to have any partner in it. So, so far as subsection 2 is concerned, it speaks suit of.
Probably you said that you can skip this paragraph. This adumbrates on section 269 only.
Yes, exactly. Well, these are the reasons. Now, my lord,
you can go to the next paragraph. The present suit has been filed. But it starts, the next paragraph starts with the present suit has been filed by a partnership firm, which is an unregistered one.
My lord, at page 147.
Yes.
147.
And this has not been denied by the plaintiff.
My lord?
See page 147.
Yes, I'm coming to that. I'm coming to 147. That is there the matter, main matter. The present suit has been filed by a partnership firm, which is an unregistered one. This has not been denied by the plaintiff. This is not so, below. I'll be placing that.
You have not stated that it's a registered partnership firm in a plaintiff.
I filed the document, below. I filed the registration document. Anyway, it has nowhere been mentioned or agitated the plaintiff firm is a registered firm, or that its partners' names have been registered as partners in the register of firm. In fact, London advocate of the plaintiff had argued that to file a suit based on verbal orders and suppliers, a partnership firm need not be registered one, and some of it, and the same is not mandatory. On the other hand, London advocate for the defendant had pointed out that the plaintiff did not put forward any document showing registration of the partnership firm, nor it had filed any balance sheet, audit report to establish his case. Here, I completely agree with the learned advocate for the defendant that plaintiff did not file any partnership certificate. Plaintiff did not file any partnership certificate, nor deed showing its existence of a registered partnership firm. For a partnership, deed is not a must. So there cannot be any, my lord, any decision to be taken against in the absence of any partnership. Anyway, I will argue that. It also did not tender any balance sheet or audit report to establish genuinity of a registered partnership. I don't know where from it is getting. Anyway, the plaintiff had produced, here, this line is very important. The plaintiff had produced the memorandum of registration number 10576 dated 14th of May 2010, issued by the Registrar of Farms, West Bengal, that was marked as Exhibit 8 in this suit. However, such document did not relate to any partnership farm registration certificate. Well, this is something peculiar. Anyway, the perusal of the document reveals that some documents required for registration form number 1 were filed by the plaintiff firm, which had been recorded accordingly. But it did not mention anywhere that the plaintiff firm has been actually registered in Register of Farms. The plaintiff could not file any other document to show such registration either. Thus, clearly, the plaintiff firm is an unregistered firm. This is the crux of the matter. Basis of the whole judgment. This is the basis of the whole judgment. Then, my lord, other issues I am drawing your lordship's kind attention. My lord, the document which has been filed, my lord, in this context, my lord, let us look at the document. It's a one-page document. You will also kindly see at page Exhibit 8 page bolo. Page 249, my lord. Part 2, my lord. Page 249. My lord, is the certificate given by the Registrar of Farms. The Registrar of Farms, West Bengal, hereby acknowledge receipt of the undermined document and intimates that it has been filed, recorded, registered pursuant to the Indian Partnership Act 9 of 1932. Mrs. Trade Center, registration number 73931. Then, my lord, again, my lord, it has been forwarded to Mrs. Trade Center, 76, Raja Ramon Sarani, Kolkata 9. This is the address of the plaintiff.
Where is that, please?
Bottom, in the bottom, it was sent, sent to. It was sent to from the office. Now, what is the evidentiary value of this document? That is in question. And my lord, in this regard, what are the records in the office of the Registrar of Farms? We have taken a certified copy. That we are trying to rely in this appeal under Order 41 Rule 27. In connection with this, nothing more. There, our names are appearing. This certified copy you have taken. This is the document we have been given after registration. I will be referring to Partnership Act on this point. This is the whole matter upon which, my lord, this suit has been dismissed. Now, my lord, let us see the other issue, how it has been dealt with.
Due to Partnership Act, I mean, Bear Act.
And also sale of goods, my lord.
Acha, sale of goods. To note kuni. Sale of Goods Act, Partnership Act. Do copy. Please continue.
Hence, the most important question which crop up here is that since the plaintiff firm in an unregistered partnership firm, can it file a suit against the third party for oral orders and supplies? And I'm putting emphasis on these oral orders. This is very important. Oral orders and supplies is in the present suit hit by the provisions of Section 69(2) of the Partnership Act. It is obvious that but for the said verbal orders or agreement between the plaintiff firm and the defendant company, the goods would not have been supplied. Therefore, the right which the plaintiff is seeking to enforce in this case is a right arising from a contract. It is also clear that contract referred to has been entered by the plaintiff firm with the third party defendant company in course of business dealing with the firm with such third party. It has to be borne in mind that Section 69 of the Partnership Act contains only a prohibition on an unregistered firm filing a suit to enforce a right arising from a contract or conferred by the said act. The firm has to be registered and the person suing has to be a registered partner. Then the suit to contract section 69, then judgments have been discussed. I think, for our purpose, it is not necessary. If we can prove that it is a registered company.
Yes.
Then next page. Then it is also well settled. Now, my lord, not a partnership is a relationship which subsists between the parties, but a partnership firm which is not registered is not an entity in the eye of law and is not a person. And is not a person. Now, my lord, it is merely a collective name of the individuals who are the members of the Partnership Act. My lord, even a registered partnership firm cannot be a legal person. Legal person is something else, who may sue or may be sued, as we find in the Companies Act, in the Societies Registration Act, etc., etc. Then, my lord, it is well positioned. Now, my lord, this position is well settled, and it would appear from the decision of the Honorable High Court at Calcutta in the case of, etc., etc. The decision was followed by, etc., etc. Then, my lord, after this, after 2-3 lines, under the Partnership Act 1890, let's got it, my lord.
Got it.
A partnership has been defined as the relation which subsists between the persons carrying on business in common with a view of making a profit. From Pollock's Digest of the Law of Partnership, it appears that partnership is the relation which subsists between the persons who have agreed to share the profit of the business carried on by all or any of them on behalf of all of them. Thus, an unregistered partnership firm is not a legal entity. Therefore, the question is whether an unregistered partnership firm file a suit. Reference there can be made to a decision reported in such and such. Then, my lord, conclusion 153.
Yes.
Paragraph 12 in the middle.
That is the conclusion of the cited judgment.
Yes, cited judgment. Therefore, in the light of the aforesaid discussion, in view of the various decisions of the honorable courts, and also being guided by the decision cited by learned advocate for the defendant, it could be said that the instant suit is indeed hit and barred by the provisions of Section 69(2) of the Partnership Act. Learned advocate for the defendant had rightly pointed out that in order to divert the plain case, which was relied upon the purchase orders diverse dates, plaintiff, learned counsel, and otherwise tried to shift the in terms of the sale of goods 1930. This is the defendant's plaintiff's argument to circumvent the Contact Act or the Partnership Act. As correctly averted by learned advocate for the defendant, the sale of goods 1930 has no conflict with the Contact Act or the Partnership Act. And there is conflict. Also, there is conflict. And being a special statute, in case of partnership dispute with a third party, the Partnership Act will prevail upon the other statutes, and thus the suit is clearly barred under Section 69(2) of the Partnership Act, which cannot be circumnavigated. Thus, in bold letters, the suit is clearly not maintainable either in present law or in form. This is the conclusion. Accordingly, the issue number 1 is decided against the plaintiff. That issue number 1 was with regard to maintainability of the suit. Then, my cause of action was decided. Then, at page 155,
yes,
the last sentence, after discussing cause of action, however, you got it?
Yes,
line.
got it.
However, this question of plaintiff having cause of action has now become redundant, since it has been discussed here and before that the suit itself is not maintainable. Accordingly, the issue number 2 is also decided against the plaintiff. Then, my lord, issue number 3, 4, and 5 at page 156.
But only the case has been settled and held again that since held not maintainable, therefore.
Each and every issue. Now, I'm just showing you, lordship, for your lordship kind satisfaction. my lord. My lord, kindly see.
Your case has been narrated, their case has been narrated, and then said, but since held not maintainable, therefore.
Exactly. Now, my lord, your lordship will get at page 157.
Yes.
Second paragraph. Yes. Now, although these questions have been raised in this suit, they have been rendered pleonastic because of the simple fact the suit itself is not maintainable and is barred under section 69(2) of the Partnership Act.
Yes.
Then, my lord, again, at page 158, at the top.
Yes.
Accordingly, in light of the above findings, all the above three issues are decided against the plaintiff because of this non-maintainability. Factual aspect has not been decided. Now, my lord. Then, my lord, the cumulative deduction of that follows from the aforesaid discussion is that the plaintiff has been unsuccessful proving its case, and these leads leads us to infer that the instant suit is liable to be dismissed. However, considering the plaintiff's bona fide intention of filing the suit, this suit is liable to be dismissed without cost. Then, my lord, with regard to the deposit made here, the learned judge was pleased to make some finding. What will be the fate of the deposit made with the register of the Calcutta High Court? That order has been given. Now, my lord, during the pendency of the appeal, we have filed an application for stay, and there is stay. Now, my lord, this is the judgment given by the court. And, my lord, the entire fate of the suit has been decided on 69(2).
Yes.
So, if we can overcome 69(2), then we will be able to enter into other issues. And, my lord, I'm praying your lordships can leave to refer to the other issues after arguing on 69(2).
Yes, because other issues probably, even if you win on 69(2), other issues have not been decided at all. Evidence not considered. So
Not
we have to
decided.
remand them.
Yes, my lord.
Unless you lose the case, then there is no scope of remanding. If you dismiss your appeal, then nothing happens. But if you allow your appeal even on that
69(2) is the
point,
main matter. 69(2) is the main matter. Now, my lord, after 69(2), my submissions will be, if I can convince your lordship, my lord.
আনতে দিয়েছেন?
Partnership টা আছে। এই যে partnership agreement।
Thank you.
শেলাপুর সেকশন এখানে একটা আছে।
69(2) actually we have seen. I mean, it was
Yes,
quoted.
it has been quoted in the judgment.
But you said that you would be citing some other judgments also regarding
Judgment.
some other provisions regarding
Yes.
what would constitute a valid registration.
Your lordship kindly see. I'm going without keeping ourselves in the in anxious position. My lord, let us go straight away to the Partnership Act.
Right.
Starting 69(2).
Right.
না দেখো বলছিস না আমার তোর যা আছে আছে My lord, as we have read in the law college,
yes,
for a contract, writing is not necessary. Agreement and offer, acceptance, consideration,
promise
agreement.
versus promise.
Up to agreement. That is section 2, my lord. Offer, acceptance, then, my lord, consideration. Then it becomes the agreement, not contract. All contracts are agreements, but all agreements are not contract.
Legally
That is
enforced.
popular question in law exam.
Yes.
Now, my lord, agreement will be contract when? When an agreement is enforceable in law,
Legally enforceable, right?
then contract. Now, my lord, I am coming to my lord. খুঁজছি তো আমি সেখানে এই যে registration of firm. My lord, in Partnership Act, there is a chapter, chapter 7. Starts from page section 56. Now, my lord, kindly see
Yes.
how the registration of the firm is to be done. Then, my lord, kindly see section 58. The registration of a firm may be affected by at any time by sending by post or delivering to the registrar of the area in which any place of business of the firm is situated or proposed to be situated, a statement in the prescribed form and accompanied by the prescribed fees, stating what are the requirements, not A, B, C, D, you logic kindly see. 1. The firm name, B. The place of the principal place of business of the firm. C. The names of any other places where the firm carries on business. D. Date when each partner joined the firm, the names and full permanent address of the partners, then duration of the firm. These are the statements required. No partnership deed, no balance sheet, nothing else. My lord, then the statement shall be signed by all the partners or by their agents specially authorized in this behalf. Each person signing the statement shall also verify it in the manner prescribed. In the form it has been, verification is there. If a firm name shall not contain any of the following, there are restrictions in the matter of firm names. Those restrictions has been described. These names cannot be crown, emperor, empress. These names cannot be included. Then, my lord, section 59 is the registration. When the registrar is satisfied that the provisions of section 58 have been duly complied with, he shall record an entry of the statement in a register called the Register of Firms and shall file the statement. Then, my lord, alteration 60, 61, a closing or opening branches, 62, change in names, address of the partners.
Right.
64, rectification of mistakes.
So only an entry has to be made in the register of firms.
My lord.
As per 59.
Now, my lord, here, up to this. Thereafter, I will proceed. Just, I want to submit one thing. Suppose, my lord, up to this, we have got this certificate, this paper, Exhibit 8. It is a paper supplied by the Register of Firms. It has got some presumptive value under section 114 of the Evidence Act.
Official.
Yes. It is a document protected under section 114 of the Evidence Act, and it is a public document under section 74 of the Evidence Act.
All right.
Well, lord, when this Partnership Act was created, which is a part of the Contract Act. Partnership Act is also a part of the Contract Act. Law related to bailments is part of the Contract Act. Law relating to sale of goods, part of the Contract Act. Now, my lord, when this act was, my lord, promulgated by the parliament, the legislature had in its mind about section 114 of the Evidence Act, also, my lord, 74 of the Evidence Act. We cannot say the legislature was blind about it. Legislature was absolutely vigilant about this. In spite of that, legislature has created section 68, my lord, kindly see Partnership Act. In spite of this, any statement, intimation, our case is intimation, my lord. Any statement, intimation, or notice recorded or noted in the register of firms shall, as against any person by whom or whose behalf such statement, intimation, or notice was signed, be conclusive proof of any fact they are stated. That is the end of the matter. Then subsection 2. A certified copy of an entry relating to the firm in the register of firms may be produced in proof of the fact that the registration of such firm and of the contents of any statement, intimation, or notice recorded or noted therein. Subsection 2 is regarding the certified copies, which I have filed, my lord, in this appeal by Order 41, Rule 27. My lord, kindly have a look to Can 1, my lord, the Xerox copy I have given. এই জায়গায় আমার কাছে আছে। My lord, the first page, my lord, is the first page is the payment of the fees. And then, my lord, oh, Can 1.
Can 1, yes.
Yes.
Xerox copy.
Xerox copy is the payment of the fees, my lord. Fees being paid to the register for the certified copy. Then the certified copy starts with the stamp paper, non-judicial stamp, my lord. Then, my lord, the certified copy, which has been folded, bearing the stamp of the register. My lord, kindly see registration number and date of registration, names of the partners. Both of them are witnesses in this suit. Then, my lord, address. Then, my lord, date of joining. Then, principal place of business. ঠিক আছে।
And the registration number tallies with your document which you
Yes,
produced?
yes, yes. Same.
Yes.
Same document. So, my lord, my requirement under the law, for maintaining the suit, I will have to produce the registration of the firm before filing of the suit. That is the law, my lord, established. Before filing of the suit, there must be registration.
Yes.
So, before filing of the suit, registration was there.
The suit was filed when?
Suit was filed in 2010, 2010, my lord.
2011. Renumbered?
Renumbered, that was renumbered.
2010 when? Because the registration was also of 2010.
Yes, before that. Should filing a date though? A date is record is আছে কবে করেছি কবে ফাইল ডেটটা বলে দে দেখে বলে দে how many days, my lord, in our days, my lord, we used to incorporate with the paper book at least the date of filing and
The date of
also
filing is there in your paperwork, 5th of June 2010.
25th of June.
And the date of that certificate is 14th of May.
Yes.
Before.
Before the suit, my lord.
Yes. Right.
So, my lord, so far as the question of registration is concerned, we have got sufficient document. And my lord, this document has got the sanctity under section 58 of the Partnership Act in addition to evidence. Sorry, I'm not 58, then 68. I'm sorry.
68, yes.
68.
And read with 67, obviously, because 67 gives a certified copy issuance power.
Yes.
So that certified copy issued under section 67 operates as proof of registration under 62. And 78 Evidence Act, public document, as you said, and 114 Evidence Act.
Presumption is right.
Very well. Because the other matters, which said that we are being very candid, the court did not decide the other matters. So if you have to decide the other matters, even if you win this on this point, if you have to decide the other matters, you have to take evidence.
Other points are there in the suit.
No,
My lord,
evidence has to be
I'm arguing. In the suit, there is no written statement in the eye of law.
Why do you say that?
In my humble submission. Because, my lord, then you will have to see the original record. Written statement, from written statement, we are getting SPC.
It will not be clear from this copy.
No, written statement was not signed or sealed by the company. No seal of the company. Even no credential is described in the as director or anything like that.
I am a director. Verification portion says.
So that is the verification. It has got to be signed, my lord. It is the order 6 rule. Order 6. Okay, ভুল হয়ে যাচ্ছে না orders. My lord, so far I remember, it is in order 6. Maybe in rule 14. My lord, kindly see. My lord. Yes, I'm correct, my lord.
Civil Procedure Code.
Order 6, rule 14.
Okay.
Pleadings. Now, my lord, order 6, rule 14 says, pleading to be signed. Every pleading shall be signed by the party and his pleader, provided that where a party pleading is, by reason of absence for other good cause, unable to sign the pleading, it may be signed by any person duly authorized by him to sign the same or to sue or defend on itself. So, my lord, when he was in the box, it was signed by Subrata Datta. When he was in the box, I placed the written statement before him, and it was proved, my lord, that it was signed by him in his personal capacity. Maybe in the affidavit portion, my lord, he has stated, but in the corner pages, in the written statement, only his sole signature was there. Nothing is there regarding.
Even in the last page, the verification page, seal of the company is not there.
No, seal of the company is nowhere. Well, record test.
Record to din ekটু But you have never raised this point in the court.
Yes, I've raised it, even I've cross-examined. It has not been dealt with here.
You argued this point.
Yes.
In
the lower court, I asked them question, I have suggested him. But not fortunately or unfortunately, both of us are in the trial court.
Oh,
এইটাই দেখছি, এতেই থাকবে। What a sheet, এটা কি? Document বাদে, all petitions বাদে, হাজিরা, print এখানে থাকা উচিত বাবা, সবুজ কাগজ। এতে কি সুবিধা Constitution affidavit plain এখানে affidavit in chief
But they exhibited an authorization letter.
My lord,
They had exhibited an
exhibit authorization letter exhibited
Exhibit
at the
A.
time of hearing. হ্যাঁ জবাব দিন। হ্যাঁ এই তো
The extract of the board resolution is also there.
My lord, we are governed by the Civil Procedure Code. We cannot speak of the procedural my lord, obligations by saying my lord, substantial compliance or like that. My lord, I have given the written statement. Folded the কথাটা ভাঁজ করে বেরিয়ে আছে এইটা, ওই যেটা বেরিয়ে আছে হ্যাঁ 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 ওইটা 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 হ্যাঁ ওইটাই ওই কাগজটা আমি ঘুরিয়েও দিতে পারি। হ্যাঁ যা একটা ঘোরাতে হবে উল্টাতে হবে। হ্যাঁ my lord, kindly see the signatures on the top.
এটা প্লেন না না এটা প্লেন না রিসেন্ট কোথাও নেই। হ্যাঁ বলেছি ডিরেক্টর নিজেকে বলেছে সেটা বলেছি। কোম্পানি সিল তো থাকবে। এখানে বলেছি আমার ডিরেক্টর তো বলা তো হবে না কোম্পানি সিল ছাড়া সার্টিফিকেট করছে না সার্টিফিকেট করছে। Yes. No seal of the company.
So my lord, this is no written statement in the IOD, in my humble submission.
So this you say cannot be cured by this filing this authorization letter.
No, how that can be?
Because the pleadings itself is defective.
Defective.
Different.
Now, another point I'll be arguing in this juncture, my lord. The question was, the matter was attracted your lordship's kind notice that Taragnath Mitra was examined.
Yes.
And Taragnath Mitra was examined as a witness of the defendant. And, my lord, there are so many peculiarities. He is accusing Taragnath Mitra. He has siphoned money. He has created fabricated bills, challans, with connivance with the different suppliers and taken money out of this. There is, my lord, there may not be any complaint before the criminal court, but complaint appears from the written statement itself and also in the company petition. When I was reading, I drew your lordship kind attention that regarding Taragnath Mitra, there were some statements. And their lordship, my lord Justice Sanjeev Banerjee was pleased to hold that no action taken against Taragnath Mitra. And no company no other companies affidavit are filed that Tarangal Mitra connived with them and etc. etc.
Yes.
Now, my lord, he was summoned.
But it was their burden to their owners, initial owners to summon him. Yes.
I'm coming to that.
To prove that he.
I'm coming. That is not proved. No allegation, nothing has been proved there. My lord, when I am accusing some person, how can I examine him in the box? Is it not, my lord, contrary to Article 20 of the Constitution?
20, yes.
Article 20, my lord, Clause 3.
20, yes, yes. 23.
Article 20, Clause 3 of the Constitution.
Right, right.
Now, my lord, next, when the person Tarangnath Mitra was in the box, instead of examination and chief by Mr. Mukherjee, instead of examination and chief, that is very interesting. He wanted to cross-examine Tarangnath Mitra. And, my lord, I think, my lord, he wanted to invoke Section 154 of the Evidence Act. And thereafter, after the cross-examination, without any chief, my lord, as we know, as usual matters, when one witness will be in the box, my lord, and he will be saying something against me or against my case, then I can pray for a leave to put, not cross-examination, my lord, to put questions like cross-examination. My lord, cross-examination cannot be done by any person against the adverse party, according to Section 138 of the Evidence Act. Only adverse party can cross-examine. Each and everybody cannot cross-examine. That is the Evidence Act 138. If that be so, my lord, he cross-examined. My lord, without deferring the matter, coming to this honorable court, I did not raise any objection. He went on cross-examining. All right. He cross-examined. I will be referring to those things, my lord. Thereafter, when I stood up that I want to cross-examine him, he raised objection. No, cross-examination against cross-examination cannot be. My lord, in fact, his examination is in the nature of examination in chief. And I am always, my lord, it is within my right to cross-examine because I am the adverse party, Section 138 of the Evidence Act. Then, my lord,
you are not permitted to cross-examine.
Then, my lord, I had to come here, my lord, thereafter I got the opportunity. There, again, my lord, again illegality. Again, when he was being cross-examined by me, in the last but one day, nobody appeared on their behalf. He was discharged. Thereafter, again, he came up for cross-examination. Then, my lord, he was allowed to cross-examine. Well, in his language, cross-examine, but that was examination chief. But I was not allowed to cross-examine on that part.
It was a sort of recall.
That was not written. As we know, as we have understood.
No, Mr. Mukherjee cross-examined. The defendant cross-examined.
That's in chief in nature.
The chief examined. Examined. After that, you cross-examined.
Because they did not appear.
I got an order and then you cross-examined.
Then again he made in chief without any recall application or without any recall. That should be recalled. That is the sequence given by Order 18 Rule 4, Section 138 Evidence Act.
But without a recall, it cannot be done.
Cannot be done.
138 itself says so.
Yes, ma'am.
To explain away some admission that can be done or some certain circle.
And 154, my lord, without the leave of the court, 154 was proceeded with. My lord, kindly see section 154.
Evidence sector din. Evidence sector আছে কিনা দেখুন। এগুলোর মধ্যে দেখুন।
আচ্ছা দুটোই my lord, we have got our books. আছে
Evidence sector বলা হলো। তলায় দেখুন তো তলায় একদম তলায়। কম্প্রেজেন্টের তলায় স্পেসিফিকের তলায়। না নেই। আপনি একটা নোট করুন আজকে না হলে চলবে পরের দিন এভিডেন্স একটা নেই।
বেশ একটা পাওয়া গেছে।
এই ভারতীয় এই
ন্যায় সংহিতা
ন্যায় সংহিতাতে চলবে উপাসে অধিনিয়ম
অধিনিয়ম সাক্ষ্য অধিনিয়ম
সাক্ষ্য অধিনিয়ম ওটাই
সাক্ষ্য অধিনিয়ম
সাক্ষ্য অধিনিয়ম না দ্যাটস নট অ্যাপ্লিকেবল টু আস ওইটা রয়েছে ওখানে
এটাতে দেখি এভিডেন্স একটা আছে এটা
হ্যাঁ ইয়েস
old one is also there
yes old one should be there
thankfully yes Mr. Mukherjee got the shock of his life.
Now, after this, if you have to go on for Shakho Odiniyam, that would be a too
No.
much situation.
Shakho Odiniyam book is there.
Yes,
that
yes.
is not applicable to us. So clause গুলোকে ভেঙে একটা করে সেকশন করে
Yes, is cosmetic changes.
No, my lord, I'm just giving one example. My lord, I am referring to section 114 of the Evidence Act.
Yes.
You will also kindly remember there are several clauses A, B, C, D, E, F, G.
Exactly, illustrations and all.
All those clauses
Broken
have been made different sections.
Broken up.
Sections.
Just cosmetic changes.
Yes.
And in the criminal law also the provisions regarding women have been brought forward.
Yes.
As if the provisions are brought forward, the crime against women will reduce. Women are given importance
Yes.
on paper. On paper. If you go on the road, you find the same thing, whatever is happening. The same patriarchal mindset, same thing. Same patriarchal mindset. But the sections have been brought forward.
Yes.
So we are giving importance to women. Someone said, why celebrate a Women's Day? I mean, every day should be a Women's Day.
Right.
Why shouldn't it be? Like that. Mr. Mukherjee, sorry, you were saying something.
I was saying that here is a situation with these three new acts which have come is more or less putting the old wine in the new
Yes,
bottle.
just to disturb whatever we have learned.
It's becoming a very big
Just to ensure that people who are learned, who know the law, they have to unlearn. People who don't know the law, they get a premium.
Exactly, Miller. Exactly.
So we always remember, people remember by 114, 116 or whatever. I mean, we don't remember by 107, 106.
Each and every day I'm facing difficulty. Your lordship knows, my elder son is here.
Yes, absolutely. And he's quite competent in his
And my youngest son is practicing in the criminal court. And we are sitting in the same premises, different rooms.
Yes.
If there be any difficulty regarding...
You have to go to them.
No. They are coming to us asking what is the section. I'm just remembering the old section.
Exactly. That is
just comparative table.
This compendium has to be kept. The comparative chart is given in every book. That's why.
We have to see it.
Every book there is a comparative chart.
Yes. And not one section is missing. Have you noticed that?
Yes.
Right.
Not one section is missing.
Right.
What is 154?
Yes.
Old section?
Initially, I was shocked because I got the 154 of the new one.
No, you also kindly have it. No, don't take the...
No, we have got it. Got it.
My lord,
Party to his own witness.
No, your lordship got it.
For both of us.
The court may, in his discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party.
Yes. So chief in the nature of cross-examination, as you are saying.
This is not cross-examination. And section says cross-examination only can be done by adverse party. By adverse
138 is very clear. Scheme is very clear.
Absolutely.
Examination, cross-examination, if permitted, recall.
Yes.
To explain away those.
I remember, my lord, in my junior days, I faced this question in this way, my lord. In one partition suit, one brother filed a suit and four brothers are two in a group, or they are made, my lord, two adverse. So that's why they are made defendant 1 and 2, and other two are made to perform of defendants. Examination was going on of the plaintiff, and thereafter questioning will be done. He could not say anything elaborately. That's why suddenly performer defendant's lawyer I will cross-examine because I am a defendant, and he was allowed by the learned court. But I was in a trouble. How that can be? In chamber, my lord, throughout the night I was searched. In Woodrove's book, I got it that adverse party can nobody. So he was not an adverse party. Then file an application. Entire evidence was expunged.
These are true civil intricacies.
Yes. Yes.
Academic interest of academic interest.
Yes. Academic interest, and it is very difficult also, and it is very interesting also.
Yes. To the party, although it is not academic, it's very, very real. But even then, this is the charm of civil matters.
Yes, exactly. That we could not find in writ petitions.
Nowhere else.
My lord, I just remember one sentence. Lordship Justice Bhaskar Bhattacharya, when his lordship was in court number 5, after getting the new determination, I was there moving on writ application. And after disposing of that, several documents, my lord, annexure A, annexure 2, no evidence act, nothing else. Whatever is taken from the other party, taken from the government office, everything my lord, annexed. Then my lord observed, Mr. Dey, in this jurisdiction, I am forgetting the evidence act every day.
Actually, that.
No, so far as I remember, and if I remember correctly, your lordship was otherwise dealing with civil matters.
Yes.
No writ matters, no sessions matter.
No. I've never done any civil matter, never done any writ matter except one in a vacation and one criminal matter in a vacation.
When I kept the roll number ticking that it is there.
Yes, I was with somebody.
Yes, I know. Anyway. So
154 you are relying on also.
Yes, I'm relying upon
cross-examination is also.
And also I have been debarred from cross-examining the last part of his chief, which was done without recalling.
But then also 154 says permission has to be taken from the court.
Yes.
And if new matter is by permission of.
My lord, here.
Yes.
It cannot be, the 154 is not giving permission for bare cross-examination. There must be some chief.
Chief would be akin to cross-examination.
Yes.
Questions with permission of court may be similar to cross-examination questions, adverse questions. Like this is a prime example of that, because if such a person, his allegations is, the defendant's allegation is against this person.
Yes.
So if he has to be cross-examined, examined, it has to be in the nature of a cross-examination. And so he must have denied that he, obviously.
Oh, yeah. Well, I'll be placing the evidence.
Couldn't have admitted that he colluded.
No, I have not admitted.
No, the Tarak Mitra must not have admitted that.
No, he has not admitted.
How can he admit that?
Rather, he has proved my case. He has proved.
Tarak Mitra will obviously say that I have not colluded.
Those things are genuine, everything.
But probably they wanted to discharge their owners because they have alleged that Tarak Mitra, there was collusion.
Even the witness of the defendant, my lord, Subrata Datta, who was one of the directors at that point of time.
Yes.
His examination is absolutely, my lord, hopeless.
Hopeless?
Because well, he says, I know nothing about it. So entire evidence goes. As I learned, my lord. If he says in cross-examination, I know nothing about this case, then my lord, entire evidence goes.
Maybe a stray sentence.
No. In my cross-examination, several sentences he has said. I put the questions very specifically. Well, I'll be placing those evidence, my lord, before your lordship. Now, my lord, I was. Sale of goods exchange?
Yes.
Just have it.
Yes.
Before going into the other sections, my lord, I'll be drawing your lordship's kind attention. This is my duty, my lord, that your lordship kindly see section 2, subsection 15. Expressions used but not defined, not defined in this act and defined in the Indian Contract Act have the meaning assigning to them in that act. So, my lord, we will be going to Contract Act. We will take the help of the Contract Act when there is no definition of any expression in this act.
Right.
Fine. Then, my lord, your lordship can. My lord, can you see chapter 2, section 4?
Yes.
Subsection 1, sale and agreement to sell. And the chapter is formation of the contract. So it is something different from Contract Act. That is why formation of contract has been given by the legislature here. Contract of sale. Section 4, sale and agreement to sell. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. There may be a contract of sale between one part owner and another. 2, a contract of sale may be absolute or conditional. 3, where under a contract of sale, the property in the goods is transferred from the seller to the buyer, the contract is called a sale. But where the transfer of the property in the goods is to take place at a future time or subject to some condition thereafter to be fulfilled, the contract is called an agreement to sell. An agreement to sell becomes a sale when the time elapses or the conditions are fulfilled subject to any the property in goods is to be transferred. Then, my lord, shall we come to section 5?
Yes.
Formalities of the contract. Well, formalities of the contract. Contract of sale, how made? A contract of sale is made by an offer to buy or sell goods for a price and the acceptance of such offer. The contract may provide for the immediate delivery of the goods or immediate payment of the price of for both, or for the delivery or payment by installment, or the delivery or payment or both shall be postponed. Then subsection 2 is very important for us. Subject to the provisions of any law for the time being in force, a contract of sale may be made in writing or by word of mouth. My lord, we have seen, my lord, oral orders in the judgment in the
Yes.
or partly in writing or partly by word of mouth, or may be implied from the conduct of the party. Even, my lord, for the time being, in this juncture, I want to, my lord, draw your lordship's kind attention. The defendant has admitted 2 of the bills, but he has not produced any order in writing. Those are also
By conduct.
by oral orders.
Oral and by conduct also.
Yes. Then, my lord, then, my lord, we have supplied the goods. There may be defect. There may be any sort of defect in quality or quantity, anything like that. Then, my lord, section 16 will apply. what should have been done. No action has been taken by the defendant under section 16.
But have you laid independent evidence to say that those goods were supplied?
My lord, I have independent evidence I have given.
Contract you need not prove.
Even from the government record, it appears the supply was there. They have taken, my lord, tax reduction.
Regarding all the entire bills, all the bills.
All the bills, 12 bills.
Those were exhibited.
Exhibit 7 series. I'll produce those.
Have they produced those documents to show subsequently they returned some of those?
That document is not coming. I have cross-examined. They could not produce. That they have returned the tax.
And that refund also had to be before the suit. Otherwise,
Only, my lord, one certificate of the consultant is given. His consultant. That is no document at all.
No evidence of that consultant.
And that consultant was not in the box.
not in the box.
No.
All right.
Then, my lord, kindly come to section 31. 31 and 32.
Yes.
These are the, my lord, performance of the contract, duties of the seller and buyer, and payment. Everything is there. 31, 32.
Yes.
Then, my lord, under section 41, buyer will examine the goods. Entire thing is there in the Sale of Goods Act. Then 42 is acceptance. Then, my lord, right of the unpaid sellers, section 45 and 46.
Yes.
Then, my lord, the last point, last section, section 55. Suit for price. This is the suit for price, my lord, under section 55 of the Sale of Goods Act. My lord, apart from that, there is a registration of the partnership. There are cases, your lordship knows, my lord, that in case of special act enforcing the rights of the under the special act, registration of the partnership firm is not necessary. There are several cases. Suppose, my lord, there is a tenant in the partnership property. You want to evict the tenant. No registration of the partnership deed is necessary for special act.
But Partnership Act is a special act for partnerships. And section 69 governs any sort of legal action and any sort of
Okay, my lord, I will not go into the
that's not a very
controversy,
strong point of yours.
Yes,
It's an arguable point, but probably we won't accept that. Because partnership section 69 is blanket.
it is also a special act. My lord.
True. Special
And I am
getting sale of goods.
Sale of goods. I
Section
filed this
69
suit in this section.
Yes, but the suit, the section under which you file the suit is immaterial because whatever's under whatever section you file in is suit.
Yes.
Section 69 is an umbrella which covers all suits under various.
That is all right.
That's probably the weakest.
We did
link
not
in
waste
the
our
chain.
time on
Don't waste your
this
time
point.
on that.
Waste our
We
time
are
on this point.
taking your argument on that,
We
but
have got the registration.
yes, right.
We have got the registration. Now, my lord, I'll be placing, my lord, the entire evidence and the document, and I'll try to show that the relevant materials are before your lordship. And I'll be praying that this honorable court will decide the matter, exercising power under Order 41, Rule 31. On the next day I'll be placing the evidence on record. This is very interesting matter. But, really, I am grateful to Mr. Mukherjee. I have learned something from him.
You mean to say the other way around?
No. My lord, incidentally, I say, incidentally. I'm taking your lordship kindly. My lord, he is my relation because he is my Guru Bhai.
Guru Bhai as in the field of law or
In
religious?
field of law.
Acha.
Field of law. How? My lord, I'm coming to that. His revered father, my lord, was our professor in the Calcutta University.
Oh, acha.
And he used to teach us civil procedure. I'm just giving one incident, very interesting incident.
Yes.
First day, Mr. Mukherjee came to the class and said, boys and girls, it is very difficult to teach you civil procedure code by 32 classes.
That's absolutely.
Which I cannot acquire by 32 years practice. Yes. Then next day, he brought a plaint. My lord, in this way, he brought a plaint. Here you see, students, you see, this is the in the court of the district judge at Alipur. For determination of this, you will have to see section 16 to 20. In this way, we have learned, my lord, and really speaking, for the last 55
You're
years,
envious of you.
I'm just keeping that in mind. I'm grateful to him.
He was in the law college from 59 to 79.
We are envious of his
Yes.
students.
Yes. Whenever I used to go to Alipur court, there, illustrious Sunil Bose was there.
Yes, absolutely.
Sunil Bose.
Who doesn't know? Yes.
Yes. He was master in Mohammedan law. And Mohammedan law cases, I used to learn from him. And whenever I go to room number 4, I used to touch the feet of Mr. Mukherjee.
Sir, after all.
Yes.
Teacher.
Yes. Even today, I'm remembering.
He has left 35 years back. I also remember some generation of
Definitely,
that
Mr.
time.
Definitely.
Your family also remember
Obviously,
the
Mr.
generations.
Mukherjee. Definitely.
I remember your grandfather arguing in a matter. He was arguing for the plaintiff at that point of time. He used to wear a dhoti and a achkan. His junior was just pulling his gown like this.
Other side.
Yes, he was with the defendant. Then he said, Your Honor, you would know that this matter, this will be argued by the plaintiff. Now kindly hear.
I would argue for the plaintiff.
Split second.
And now
this will be argued by the defendant. That's my submission before the court.
Yes, I've heard.
With a split second he did. I've seen it with my own eyes.
Justice SP Talukdar told me once, it is Justice Talukdar's, my grandfather had once probably come to this court, the High Court, to appear before somebody. He did not come, as you know. Probably he had said to the judge that I may occasionally honor your lordship. I may occasionally call your lordship your honor because I'm coming from the district. So he said, I may occasionally honor your lordship. So I mean,
he was
the
a
width,
different
I mean,
type of person.
of the entire generation, of that entire generation.
He was a different type of a person.
We have only heard of these things
Yes.
from people like you and my father, obviously.
I remember Mr. Bakshi appearing in an appeal against me. I was a young chap at that point.
Obviously, yes.
Maybe 5-6 years practice. No.
Prithvish Bhai.
Prithvish
Bhai.
There.
He enters the court and to ask the court, is this thing written in the plaint? Court says, yes, it's written. Then I've lost the match. He went, anyone can do now, today. No one can do it.
No, I've seen that Mukherjee.
Mukherjee.
No. Sometimes I forget.
No.
Due to age.
Yes, this is very much coming to me also. I'm forgetting. Biggest of all forgetting is to face. This matter will be fixed up sometime in February. That will be easier.
Why?
No.
Tomorrow, day after.
Continuity will be lost.
No.
Yes.
Why I'm telling you?
In the meantime, you will also be engaged in several other matters. I also.
Why I'm telling you? There is a reason behind it. Tomorrow and day after, I'll be stuck up in some other court. I won't be able to come. And Friday, your lordship takes up.
No, we'll keep it next Monday.
Monday, 21st. Cutting short because from 22nd, I won't be available in court.
Let it be on 20th. Let us see, Mr. Mukherjee, how it proceeds. If you are in difficulty, we won't take up.
I would be in very
because
big
he's continuing, Mr.
Yes. Very good.
If you are in difficulty, we'll consider that.
Next month, but I would be in a very big difficulty. That's why I won't be in town.
From 22nd?
From 22nd to 27th.
We'll consider that, Mr. Mukherjee. No difficulty on
let
that.
me
Then
complete my
he can complete, then we can keep it if
Hey,
necessary 28th or some other day.
As you lordship, as you lordship. Sombat থেকে।
Cable Junior is here, my lord.
Very difficult burden to. No, not difficult for you, Mr. Raju. You can very well do it, but hard in part. The matter will be listed for further hearing on January 20, 2025. It will appear as a part heard matter.
Part heard.
Yes, yes. If it is part heard, then it appears as a part heard, another part.
No, I was just seeing a notification wherein taken up, both of you will be taken up single benches. I don't know
Every
whether-
Friday we do that because there we have a residue of
some judge.
civil divisions. Some civil
Yes, yes,
divisions
yes.
have been assigned to us.
Yes, yes.
But that we can take up only on Fridays, and we don't think I won't have the time because in the morning we can take up origin side matters. In the afternoon, either some residuary part heard matter of some other division bench or appellate side matters.
Yes.
We have contempt matters, review applications.
I know that.
You know, we are
But I don't know why.
His
how
Lordship Justice
about
Raja Basu
400
Chaudhury's-
matters have been assigned to your bench.
100.
100.
100
matters
me.
to your bench, 100 matters. No, you have been given a power.
My lord has been given a single bench.
Single bench to my lord justice.
Kumar is also taking.
Yes, when I sit singly, Justice Kumar also naturally goes there.
The matter which was assigned to my lord justice Shampadatta Pal, hard
That-
has
that
been
has-
assigned to
that
my
has-
lord justice Kumar.
Yes, we take those up on Fridays. That is it.
Friday.
Otherwise, these matters will suffer. So many appeals
Yes,
are
yes,
already there.
exactly,
before.
exactly.
Just see in front of you.
Exactly.
My officers are regularly complaining, don't take further mentioning.
Where we'll go, my lord? Where the litigants will go.
You, when we rise, convince them. Why we
After,
take,
after this matter is
you
finished,
just, Mr. Dev, please convince them. The senior
After-
people like you will convince them. You'll be
after
able
this
to convince
matter
them
is finished-
why we take up so much trouble.
after this matter is finished, I would mention before your lordship another matter which was again parted before another division bench.
That is a difficult. Turan, like. Ashwa.